All right. So, like we said, today is HOA board cert, guys. HOA means subject to Chapter 720 of Florida statutes. If you're in a condo or a co-op, today is not for you. I'd love for you to stick around, get some extra education, but I know, let's be real, the real reason you're here is to get the certification and to sort of check that box. So if you're condo or co-op, that's not going to check the box today. So HOA 720 only. All right, let's dive in. HOAs are actually kind of my favorite. So this should be fun. Now, there's my profile. Feel free to look through there. All right, why are we here? Let's start basic here. Within 90 days after being elected or appointed to the board, you are supposed to, as a new board member, complete this educational course. It has to be a course that's approved by the DBPR. It's going to be good for up to 4 years. So after today, you're good for a while. Now, they made this nice and clear that they want to make sure we're covering essentially 4 big topics. So that's your financial literacy, transparency, record keeping, fines, and notice and meeting requirements. Those are the big topics. Now, I should also give you a sort of a little bit of a disclaimer. We have a lot of slides. There's a lot of information here. I'm not going to read through every single one. I'm going to try and, keep us moving. I know we're allotted, I think, for 3 hours. Realistically, I can talk pretty fast. I was, raised in New York, so it's still in me. I can talk quickly. We're going to try and get through it. And, we'll hold questions till the end, and hopefully we can do it in 2.5. And again, you guys will have the slides. Those will be sent to you, right, Jeff? So
That's what I was going to mention. You don't need to take copious notes. You don't need to go nuts after the required evaluation at the end. And again, the link will be placed into the chat after you fill that sucker out and submit it. The screen after submitting it will have a link to download the slides.
Okay, great. So again, you'll have them all. You can read through them at your, leisure. It's always a good time, when you're sitting on the beach, who doesn't want to read through some HOA board certification information? So we put it all in here. We give it all to you. I'm not going to read it all in detail, but you'll have it. So it'll be at your, at your disposal here. All right. Now, keep in mind, if you don't get the certification done, technically you're suspended from the board. That's the way the statute reads until you comply with this requirement and you get the certification done. It's a little strange. The board technically could temporarily fill that vacancy. But again, if you get it fixed, then you're back on the board. So it's a little silly. But either way, get your certification done and you're good to go. You have to hold on to that certificate for 5 years. And again, if you don't have it done or if you don't have that certificate, and the board maybe doesn't realize that one of the directors didn't get it done in time or doesn't have that certificate, it doesn't mean that the board's action is somehow now invalid or void or any of that. It's still a legitimate vote that person cast, and the board's action is not going to be challenged because of it. So, all right, this is what we talked about a little bit too, that Jeff was talking about, the continuing education. This was a new change. Now, essentially, and we'll talk about some other references to sort of events in the last couple of years with various HOAs and other associations. And this is what resulted in some of these changes. We had some issues with an association that got into trouble where the board was doing things it shouldn't have been doing. And without getting into too many details, there were some criminal allegations, there were some arrests, there was some money that was not treated properly and misappropriated. So because of that, there's been a little bit of a fallout. It was a big news story. If anybody was paying attention in the last couple of years, the arrests kind of, rocked the news here. So, because you don't think HOAs, you just sort of assume your neighbors are doing what they should be doing. Well, not always. So again, part of that was, let's make sure our board members do understand their duties and do understand what they're supposed to be doing and are really educated. That was part of, what came out of this. So now you have a continuing education requirement. If you're in an association that has fewer than 2,500 parcels, you have to do 4 hours of continuing education annually. If you're in a really big association, the 2,500 or more, it's 8 hours of continuing education. So I think it's actually the legislature's purpose was probably twofold. One, make sure everybody's educated, and 2, maybe keep those people who aren't willing to do that education off the boards. but who knows?
And
So
George has a great comment in there too. One of our regulars. Why are HOA and condo requirements so darn different? It seems like all the time. And I
good
wish we had
question.
the answer to that.
Good question. You're right. And it used to be that HOAs and condos were very similarly treated, and 718 and 720 had a lot of parallels, but now they've just slowly diverged. And slowly but surely now HOA world and condo world are two different beasts altogether, it seems. So
And everything coming out of Tallahassee makes sense 100% of the time, right?
correct, correct. Yeah. So yes, so here we are. So now you have to do some continuing education. And as we talked about, the problem is you're supposed to do it, but we don't really have any guidance in terms of what that means, what these classes are, when they're going to be approved, how they're going to be approved. And we are waiting for the update. So we're just sort of in a sit and wait holding pattern right now. So we'll keep you posted. Hopefully you get our email blasts, and we'll let you know when we have more information. All right, so let's jump in 720 Florida statutes. All right. Like I said, HOAs, condos, different animals now. HOAs essentially, they're a creature of common law. That's really, HOAs kind of have a little more discretion. The board has a little bit more power in terms of whatever their governing documents say. That's probably going to be what controls, because again, your governing documents were recorded against the land. You purchased your property aware on notice that those restrictions are there, that those covenants are there, because they're recorded against the land. Now, condominium associations, a little different. The statute is what created condominium associations. So the way sort of there's legal analysis that ends up being a little different because of that. But all right. This is another interesting sort of legal argument, and we won't get into it too much. There's a whole long drawn out analysis here when we talk about, okay, which version of 720 applies. If you're a community that was built in 1999, Chapter 720 was very different in 1999 than it is in 2025. We already know we've had many changes in the last couple of years to 720 after not having many for a lot of years. So which version applies? That's a question we get a lot. Now, the answer is, and I know you don't like this answer, so preemptively don't shoot the messenger here. It depends. And I know that's your typical lawyer answer, and I'm sorry I can't give you, black and white answers all the time here, but it depends. So basically, and again, there's a few factors, and we're not going to get into really the in-depth legal analysis here, but the way it works, there's a contract law principle, the substantive law that was in effect at the time of the contract. And in this case, the contract is your declaration. So when your declaration was recorded, is incorporated into that contract as if it's part of the contract. So if your community was built and your declaration was recorded in 1999, in theory, your declaration is incorporating Chapter 720, the version that was in place in 1999. Now we get into the question of, well, as the statute changes, do we change with it essentially? And again, that's where the it depends comes into play. If you have Kaufman language in your declaration, so Chapter 720, if your governing documents actually say we are subject to Chapter 720 as amended from time to time, and those are the magic words, that is Kaufman language. If that's in your declaration, you've already built in that, hey, we are going to change with the statute. Our declaration will be subject to Chapter 720 as it's amended, as it changes. So even though we were developed in 1999, we have Kaufman language. So our declaration is now subject to Chapter 720, the 2025 version or 2024, whatever, 2025 version. If you don't have Kaufman language, then that's not a clear-cut answer. Then we're back to it depends still. There may be some changes that still apply to you in the statute, or there may be some things that are in your declaration that will not be subject to those changes in the statute. And that comes back to whether or not how the statute was changed, how it was the drafting of the actual language. And then also, is the change to the statute, is this affecting a substantive right or a procedural right? If the change is procedural in the statute, then it's going to apply to everybody because there's no substantive right that's being impaired. If there's a substantive right, then there's an argument that no, our declaration, our contract from 1999 is what actually controls. So this, we'll get into how this can affect you a little more substantively near the end. We'll kind of circle back. But the procedural example, the easiest one to tell you is, and I know we're not even in condo world, but it's the easiest example. In the world of condominiums, Chapter 718 changed how they do elections, and the statute outlines exactly how they have to do their elections. So it's the election process. So it was a procedural change. So now all condos follow the same procedure because the statute changed. It was a procedural change and that applied to everybody. So if something happened like that in the world of 720, you guys would be subject to that too. Like I said, it gets a little tricky when we're talking what's procedural, what's substantive, but that's the very, very Cliff Notes version of the argument here. And again, all of this is meant to be sort of your basic 101 course. So we kind of have to Cliff Notes everything for you guys today. All right, then there's a question. All right, what about Chapter 716 or 617? 617 is the not-for-profit statute. If you are governed by 720, 719, which is co-ops, or 718, which is condominiums, 617 also comes into play sometimes because, again, it has some extra provisions that could sort of fill in some gaps. But ultimately, your specific chapter, so again, the HOA statute 720 or the co-op statute 719 or 718 condos, those are going to control over 617. So if there's a conflict between them, the one that starts with the 7 is the one that wins. That's the easiest way to think about it. But if there is something in 617, it's possible that you're going to be subject to that as well. Now, what about conflicts internally within your governing documents? Let's talk about that real quick. Now, when I say governing documents or governing docs, if I accidentally let it slip and we use sort of slang here, pardon me, but work with me here today, guys. That means that's a series of governing documents, a series of documents. It's not just one thing. Your declaration is one document on its own. Then you have an articles of incorporation and you have bylaws. And that's the sort of your order, your hierarchy order. Your declaration controls, then the articles, then the bylaws. So the way we say it is, you can remember the old ad, a little dab will do ya. Declaration, articles, bylaws, dab, D-A-B. Your declaration is what we kind of joke that's your constitution. That's what has all of your restrictions, your covenants. If you're a 55 and over, if you have, ARC requirements, those are all included in your declaration or should be. Your articles of incorporation, that's the document that you file with the state, and that's what created you as an entity. Your bylaws typically contains sort of how you govern, meeting notice requirements, how many board members you have, things like that. That should all be in your bylaws. So that's the priority there. All right, so let's dig into some of the substance here. Membership meetings. Now, we're talking about membership meetings. So membership meetings mean, and I don't say this to sound like I'm, teasing anyone when I say it, but membership meetings are for the membership. It means your membership is voting. So membership meetings realistically are few and far between in the world of HOAs. Typically there is one per year and it's your annual meeting, and that's where you're doing your election and you're doing all of that. And often you don't even have that meeting because no one shows up and you can't have quorum. But just so you know, your annual member meeting, you have to look at your governing documents, you look at your bylaws. There should be some information there in terms of when it should be held, how it should be held, where, times, all of that. You do check your bylaws first. If you can also keep in mind, you could always amend that if that's something, that's either you've kind of lost track. It says your annual meeting is supposed to be held in December, but you guys have always done it in February because it's always been easier or whatever. Maybe that's something you want to change. Often there's language that says, time and place to be determined by the board. That's nice when you have that flexibility already built in. If you don't have it, it might be something you want to do if you're looking at doing any amendments. So you have to follow what's in your bylaws in terms of having your annual meeting. Special membership meetings. So again, maybe it's a membership meeting where you want your members to vote on an amendment, or, vote on something else. Typically, again, your members aren't voting on too much. And so special membership meetings are rare, but it could happen. The board can call a special membership meeting, or there's actually language in the statute that if 10% of the total voting interests petition for a membership meeting, or check your governing documents if there's something different, then a membership meeting can be called and held. Agendas, unless your governing documents require otherwise, your notice for the annual meeting technically does not have to have a description other than that you're holding your annual meeting. We typically recommend you do it anyway, have the agenda on there. Why not? A special membership meeting, you have to have the description. So again, when you're formatting your sort of notice and agenda, why not include the agenda on there? Notices have to have the date, time, and location of the meeting. That should be common sense, but again, we'll be nice and clear. Look at your bylaws in terms of notice provisions. If the bylaws don't say anything about giving notice, then it's a 14-day notice. So the association must mail, deliver, or electronically transmit notice at least 14 days before the meeting. That is, and again, condo world, HOA world, when we talk about annual meetings and elections, very, very, very different. So HOAs, 14 days, one notice, that's totally fine. Again, very different than condos. You have to have evidence that you properly complied and you sent the 14-day notice. Evidence really just means an affidavit. So whoever prepared that notice and got it out and mailed it and all of that has to sign an affidavit, and you have to have that affidavit in the official records. All right. Electronic notice requirements. So again, you can send notice via electronic transmission, so emails, whatever it is, if that owner has consented to receiving electronic transmission. So we try and encourage everybody really to get onto e-voting, to get into electronic notices. It does make life a little bit easier for your boards and for management, because now you can send out these emails, you can cut down on the mailing expenses. That's one of those things that now, since COVID, everybody really has sort of started to get on board with it. And we encourage everybody. It does seem to be working out for everyone. So if you don't do e-voting, if you don't do e-notices, talk to your management team. This might be something you want to look into. I know initially when electronic voting came out, some communities were a little scared because they were worried it was going to be an extra expense, whatever it was, because you have to really work with a approved platform and be following the right steps. They were worried it was going to be an additional cost, but now there are a couple different companies there, and the cost has really seemed to come down, and it's very reasonable. And when you compare it to the mailing cost, it all sort of works out in the wash. So look into that if that's something you guys want to, if you're not doing it yet, look into it. So email addresses, this is the other part of it. If email addresses were given as part of this consent process, you have to be aware those are now going to be part of the official records. If somebody revokes their consent and no longer wants to get email notices, their email address has to now be removed from those association records. Be aware of that. All right. And also, small caveat there, you can't use the electronic notices if you're going to try and recall a director. Don't know why, but there we are. All right, you can also broadcast notices. There's language in the statute for that. I know there are still some communities that do, have sort of an association channel. I see it more in condos than HOAs, but where they can blast announcements and they play them on replay and all of that. Now, here's something to be aware of. Hopefully this is not news to you guys. An association that has 100 or more parcels has to post the notice and agenda of their membership meeting at least 14 days before the meeting on their website. So websites are sort of a new thing in the last couple of years too. If that's not something you guys have set up, you might want to look into that and make sure you're complying depending on your size and get that set up for you. Again, your management team can probably help you with that. I know a lot of them will build out the platforms for you. But when you have that notice on your website, it has to also be obvious. You either have it in plain view on the home page, or you have a separate tab where it's clear, easy to find, nice and basic notice, because again, we want to make it nice and obvious for everybody. We're not trying to hide our notice that we're having a meeting. Members have the right to participate in meetings. Now, hopefully we all know this, but we want to make sure that your owners are heard, that they can come to the meeting, they can participate. And there's a delicate balance. We also don't want your owners to sort of derail the entire meeting and send us down, tangents all day and make the meeting last 7,000 hours. But they have the right to attend all membership meetings and to speak with reference to any items that are open for discussion or items that are on the agenda. They have the right to speak on each item for at least 3 minutes. You can adopt some rules. Again, if this is something in your community where maybe your meetings are getting a little unruly or a little out of control, talk to your attorneys. We have some prepared rules that we can help our clients with to sort of keep everybody on track and keep everything moving. Now, keep in mind too, an owner can tape record or videotape membership meetings. And again, you can adopt rules about that. Having an owner come to the meeting and they just put it on their phone and they're holding their phone up and they're just recording is one thing. Having an owner, walk up to the dais where the board is and holding the phone in the board member's face, that's not okay. We don't want that. We also don't want people showing up with, boom mics and all this equipment and really, distracting everyone during the meeting. That also would not be okay. So we would want to have some rules in place about how we're doing this. Quorum is a sort of, I don't know, for some reason it's an intimidating word. It sounds funny and it sounds a little tricky, but it's really not. Essentially, the basic rule is quorum is the minimum number of people you need to participate in order to have a meeting. So unless you have a lower number, this is where the statute kicks in and helps you guys a lot, because it's very different than what you might see in condo world. But unless you have a lower number in your bylaws, which happens sometimes, your quorum requirement is going to be 30% of the total voting interests. So 30% should be sort of your go-to default if you're in 720, unless your bylaws say something lower. So again, we've seen it every now and again where bylaws will actually say something lower. Maybe they say 20%, 25%, something like that. But 30% is probably the number you're working with. And again, that's not unreasonable. 30% is not crazy. Hopefully it's a number you can reach. Hopefully you can get people to show up, maybe gather some proxies, that kind of thing. If you don't get quorum, you can't proceed and there is no meeting. So that is why quorum is so important. And then decisions essentially, and you have to look at your governing documents, because if you're voting on something like an amendment or, maybe some sort of capital expenditure, that kind of thing, you might have a higher threshold, but typically if we're just talking about a vote at a membership meeting, it's going to be a majority. All right, proxies. I mentioned them a little bit, but let's get into sort of what they are and how they work. So typically for HOAs, again, different than condos, you can vote by proxy. You can even vote in an election by proxy, different than a condo. So for a proxy to be valid, there are certain requirements. It has to be dated. It has to be for a particular meeting, has to have the date, time, place of the meeting that it was, for which it was given. And it has to be signed by the person who's allowed to execute the proxy. So if you're a community where you don't have voting certificates, then great. It's one of your owners is going to sign, not a problem. You might be in one of those communities that requires a voting certificate and you have to actually designate if you have multiple owners, or you have to designate if it's one of the officers, if the ownership is held in the name of a corporation or some other entity, then you want to make sure that whoever the designated voter is, whoever that voting rep is, that the voting certificate sort of corresponds to who signs the proxy. Should be, sort of the same thing. The person who's voting has to be the one who signs the proxy. The proxy is only effective for the specific meeting for which it was given, but, big but here, you have a window of opportunity. If you need more time to gather more proxies, or maybe, continue your meeting to again, gather more proxies, typically, those proxies are still good for another 90 days. They don't expire. So if you have a meeting, some people show up, they turn in their proxies, whatever it is, but you don't get enough votes to get that amendment passed or something. You could always reconvene that meeting, maybe for 30 days out, send out a couple more email blasts, knock on some doors, get some more proxies, and the original proxies that were turned in for that first meeting, if you have, part 2, 30 days later, those original proxies are still good as long as you're within that 90-day window. And you could do that a couple times if you needed to. But once you go past 90 days, those first ones expire. So keep that in mind.
And while Emily's getting to the next slide here, water
Yes.
opportunity break for you there, Emily.
Thank you. Thank you.
I just want to mention that you'll notice I'm answering some questions, but not all. I don't have the ESQ after my name the way Emily does, so I am only addressing questions that do not require an attorney to answer. So just keep that in mind. Emily did mention she'll get to some of the questions that are pertinent to the topics after the presentation. Back to you.
Yes. All right. And then last thing to know about proxies, they're revocable at any time. So this is also different than a ballot. In theory, if somebody wants to vote on an election, they're not supposed to change their ballot, but you could change your proxy. So if you were voting on an amendment, or if maybe a few amendments, and originally maybe you didn't quite understand what it was or what was going on, or you just changed your mind, you could actually change your proxy, or you could, if you turned in a proxy instead of going to the meeting, and then you decide, oh, I'm actually in town, I can make the meeting tonight. You could go to the meeting in person and say, hey, I'm here, so give me back my proxy. That's perfectly fine. All right. General proxies versus limited proxies. This is sort of silly, but it's a technical thing that you guys should know the difference of. Some managers get this a little mixed up too. A general proxy really is more for quorum, and it really just, well, typically there's not a specific thing that people are voting on. Limited proxies actually identify the specific item that you're giving, your vote to, and that you're telling that person, here, vote in favor of this amendment for me, because I've already checked the box that says yes or for or whatever it is. General proxy lets the proxy holder vote in whichever way they deem appropriate. And they're both valid for quorum or count towards quorum. Electronic voting, we touched on this a little bit. So again, if you don't have electronic voting now, we really think you should probably look into doing it. Everybody seems to be sort of going that way, and it does seem to be working out for everyone and just be more convenient and a little bit easier for everyone. And ultimately, the way this gets into play, or really has to be set up, the board has to have a board resolution, has to have a special meeting to decide that they are going to go forward with electronic voting. And then once they do that, then you can get it in place. And there are certain requirements. There are certain things that again, restrictions, but all of the vendors now are fully up to date. They comply with the statutes. You don't have to worry about that if you use one of the, vendors that's been around now for a little while. Again, there's some requirements here. You have the slides. We don't need to go through each one, but the bottom line of sort of keeping in mind with electronic voting, what is important is they are able to verify where the vote came from, what the email address was, and keep votes anonymous that need to be anonymous, but still be able to track that, Mr. Jones, in house number 1 on, Green Street, that you can track that he didn't vote 5 times in the election or whatever it was. So they are able to do all of those things. All right. Elections. So we sort of touched on elections, but let's really get into what this means. Your election is a vacancy on the board that's caused by the expiration of a director's term. We fill those at the election. So elections are held at the annual meeting. Again, you're looking at your governing documents to see when that's supposed to be, or where that's supposed to happen, what time that's supposed to happen, and you're going to follow the procedure in your governing documents for the most part. Now, the trick here is your election happens at your annual meeting. So what did we say about annual meetings or any membership meetings? If you don't get quorum, if you don't get that magic number, probably the 30%, if you don't get that, you don't have a meeting. So that probably means you don't have an election, and the board rolls over and we just sort of continue on, and here we are. That's what happens a lot of times, and we hear it, where we have an owner or somebody comes to one of these board certification classes. We also teach classes specifically on elections and all of that. And without fail, someone will ask a question and say, hey, my community hasn't had an election in 10 years. What do I do? Well, what that probably means is they were unable to get quorum at any of the annual meetings. So it's not just we didn't have a meeting and they don't hold meetings and they don't want to change the board. That may be the case, and I hope that's not. But more likely, they scheduled a meeting and quorum we didn't get quorum. Not enough people showed up. Not enough people participated. We didn't get enough proxies. And then we didn't have an election because we couldn't have the annual meeting. We couldn't move forward. We couldn't have an election. Old board basically just rolls over and stays the board. So all of those stories that we hear about, hey, this board has been the same for 10 years, or they only put people they like on. Well, that may happen because if somebody resigns or there's a vacancy at some point in time, they appoint a friend or they appoint somebody else, and you never really have that election. That's probably why. So if that's something in your community, all I can really tell you is, keep an eye out when they do schedule the annual meeting. If you're really looking to get on that board, and you really want to work on, changing the board or whatever it is, changing things up, gather proxies, go knock door to door, get some proxies from your neighbors and see if you can get quorum and see if you can make an election actually happen. But if you don't have quorum, you're not having an election. So that's the big challenge. And I understand that. Candidate eligibility, we get questions about this all the time. Hey, so-and-so is, in violation of our covenants, so they shouldn't be able to run for the board, right? Or so-and-so actually sued the association last year because there was a slip and fall at the clubhouse, so he can't run for the board, right? Unfortunately, all of those things does not mean you can't run for the board. So statute basically says that if you're a member, you're eligible to serve on the board unless you're otherwise disqualified. And there's only a few things that are really going to disqualify you. If an owner is delinquent in the payment of any monetary obligation on the day that he or she could last nominate themselves, they can't seek election to the board. They're not eligible. They can't be on the ballot. Now, in the world of HOAs, typically what happens with most elections, we're taking candidate nominations from the floor. So we get to the annual meeting, we see if we have quorum. That's the big hurdle first. If we get quorum, great. Now we're moving to step 2. We can actually move on to having an election. We can take some nominations from the floor. We open up the floor. Hey, do we have any candidates? You can nominate yourself. You can nominate each other. We get candidate names. Typically, that's the last opportunity to nominate yourself. So it does get a little awkward because you want to make sure on the night of that annual meeting that those people who are, nominating, volunteering, whatever it is, that they're actually eligible, and make sure they are current on any monetary obligation owed to the association. So that's something to check. That does come into play sometimes. So if they're delinquent, then they can't run, they can't be on the ballot. That's one clear cut, way to eliminate a candidate. Another one, if they've been convicted of a felony that was in felony in Florida or something that would be comparable to a felony we have in Florida, they're not eligible to serve on the board unless their civil rights have been restored for at least 5 years. Now, I hear people tell me, well, how would we know that? Should we be running background checks on every candidate? You're not going to know that. Don't run background checks on every candidate. But sometimes it does come up. Sometimes you did run a background check. Maybe it was a new owner and you just did run a background check on them for whatever reason, and you happen to see that this is what it is. But odds are that's probably not something that's going to come across my desk very often. Let's say it that way. Another one, and this was a new change, a person who has a pending criminal charge for forgery of a ballot, or forgery of a ballot envelope, or forgery of a voting certificate used in an election, felony theft or embezzlement offense involving the association's funds or property, tampering with physical evidence, so essentially destruction of records, that kind of thing, in furtherance of a crime, or obstruction of justice, may not be elected to any board. Now, that's an important change, and I'm going to sort of circle back to what we started with. As you remember, there were some scandals in the news in the last couple of years. One involved a very large HOA and board members allegedly doing things they shouldn't have been doing. Part of that was they weren't properly holding elections. They were hiding records. They were destroying records, allegedly. But they were arrested, so allegedly. So because of that, they had pending criminal charges because they were doing these things they shouldn't have been doing. So it all sort of works together: forgery of ballots, destruction of evidence. These are all improper behaviors anyway, and again, crimes. But lo and behold, now we've actually put it in here that if you have any of these pending charges, you're not going to be eligible to be a candidate on the board. Makes sense. Now, Interesting that it doesn't actually require a conviction. It just means you have pending criminal charges. So it's not quite the same threshold as you were convicted of these things. So the allegation is enough to keep you off the board. Nominations. So like I said, typically in the world of HOAs, your nomination is probably going to be from the floor. We're probably going to open up nominations and people are going to do that. But now your governing documents could be drafted a little differently. If your governing documents let someone nominate themselves in advance of the meeting, then you don't have to allow the nominations from the floor. So if you have a procedure in place that allows for advanced nominations, then you don't have to open up the nominations from the floor. You can get the nominations in advance. You could send out a ballot, that way. But that's a procedure that really should be in your governing documents, or you should discuss if you want to do something more like a condominium election where you do the 2 notices and you do that kind of thing. Maybe that's something your community would like to do. Talk to your attorneys, probably requires an amendment to your docs. But it's important to note, because if you have one of those sort of old-fashioned concepts of we have a nominating committee and they decide who they think would be the next great, generation of board members, and they pick 5 names and they tell us those 5 names. Well, that's not quite letting owners nominate themselves. So that's a little different. If an owner can't actually throw their hat in the ring, then you're going to have to allow those nominations from the floor. So if elections are an issue, talk to your attorneys, because there might be something you want to amend in your governing documents to address this, more clearly for you. Election day, if we don't have more candidates than we have seats, we're not having an election, we don't need to vote. That makes sense. If you only have, 3 candidates for 3 spots, well, we just announced, okay, those are our new board members, and there we go. We're not doing ballots, we're not voting, we're not tallying. There we go. If we have more candidates than we do have spots, we have to fill out some ballots. We want to make sure those ballots, are basically kept anonymous. So that's interesting too, the way it's handled, because if we're doing nominations from the floor, the ballot form might be blank, and then those people are writing in who the candidates that they prefer. Get with your management team and make sure you're doing this in the most sort of effective, efficient way you can. Unless your bylaws provide otherwise, directors serve a 1-year term. You may have one of those communities where we do staggered terms. Maybe it's 2 years for half the board, or 2 years. So you're electing half the board this year, half the board next year. That's something that we put into governing documents so that your boards kind of keep some consistency and you can keep things going. But if that's something that interests you and you don't have that would require an amendment. You would have to, change your actual bylaws, talk to your attorneys about it. Otherwise, everybody's 1 year. Election challenges. Any challenge to an election process has to be commenced within 60 days after the election results are announced. That's important to note. This is also interesting. So an election dispute is going to go through, it can also go through court now, but typically those election disputes go to binding arbitration with the division. And it's the Division of Florida Condominiums and Mobile Timeshares and Mobile Homes. So interesting how they got involved in HOAs, because that's not one of the things in their title, but here we are. So, all right, election of officers. So being elected to a board is a little different than your actual officer position. And this gets a little confusing sometimes, and sometimes the owners even get confused where they say, well, but I voted for Bob because I want Bob to be the president, so please can Bob be the president? Well, your owners don't get to decide who the officers are. The owners vote to put, Bob on the board in that situation. And now the board members themselves vote amongst themselves to decide who's going to be the president, who's going to be vice president, who's going to be treasurer, who's going to be secretary, and then maybe, director or whatever it is. That's an officer decision amongst the board members. That's not a unit owner decision. So again, it's a little awkward because sometimes board, the owners want to get involved and tell you who they think should be president. That's not up to them. It's up to the board. Now, typically this is done at the organizational meeting right after the election, because everybody's there. You have your new board members. Great. Here are our 5 new board members. And then now we have a board member meeting where they decide, okay, Bob could be president, Susan's going to be vice president, Mary's going to be treasurer, blah, 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 et cetera, et cetera. The only times, fun fact, little trivia, the only time directors get to vote by proxy or by secret ballot is for deciding who's going to be the officer. So it's the only time they can vote in secret. And really that's just because it involves sort of the very awkward, okay, who wants Bob to be president? Who wants Mary to be president? And, you know, poor Joe is the tiebreaker. And sometimes we'd rather write that down on a little piece of paper instead of having to say, oh yeah, that's me. But there we are. So trivia, only time board members get to vote secretly. Now, there's no prohibition against changing officers midstream or midterm at any point in time, essentially. You're not, you know, president for life, so to speak. Once they're appointed those officer spots, you could decide the next week that, oh, this wasn't a great match or whatever it is. You know, Bob really shouldn't be president. Bob's great with numbers. He should be the treasurer and we should make Mary the president, whatever it is. You can change officer positions at any point in time at a board meeting, 48 hours, regular notice, no problem. And again, it's a board decision, not an owner decision. Fraudulent voting activities. We already touched on this a little bit and I'll get into it again. So again, this salacious news story of the last couple of years, we had some issues with some board members doing things they weren't supposed to be doing. So now we've really codified these bad behaviors and we've really put them in the statute. And now they're in 720. We want to make sure that we don't have owners, board members doing these inappropriate things. Now, I would like to think that these were already essentially crimes and these were already things that people knew were improper, but we'll put them into 722 and just reiterate that you shouldn't be doing these things. So the person who engages in the following acts of fraudulent election voting activity commits a first-degree misdemeanor. So an actual crime that could be subject to prosecution. Willfully, falsely swearing to or affirming an oath or affirmation in connection with or arising out of voting activities, perpetrating or attempting to perpetrate fraud with a vote cast, to be cast, attempted to be cast, preventing a member from voting by fraudulently changing or a ballot envelope or a voting certificate, menacing, threatening, using bribery to try to influence, deceive, or deter a member when they're voting. Again, I would hope you guys already know this is inappropriate behavior, but now we're really reiterating. We want to make sure elections are done, you know, on the up and up, and nobody's votes changed. No fraud is involved. No paperwork is changed that shouldn't be. No one is intimidated or threatened from, you know, casting their vote, bribed to cast a vote a certain way. We need to make sure all of that behavior is addressed. There's more, you know, using force, violence, all of that to keep people to vote from voting or making them vote in a certain direction. So this was new stuff that was put into the statute last year. So it's interesting because, again, you could tell it was definitely of the time. Each of the following constitutes a first-degree misdemeanor: aiding, abetting, advising a person in the commission of a fraudulent election voting activity, agreeing, conspiring, combining, confederating with at least one person to commit a fraudulent election voting activity, having knowledge of fraudulent voting activities. All of this, again, first-degree misdemeanor, actual crimes. All right, vacancies on the board. We touched on this. Essentially, you may have a board member who resigns, who moves away, or you know, may pass away, unfortunately, whatever the reason may be. Any vacancy that occurs on the board can be filled by an affirmative vote of the majority of the remaining directors, unless you have something different in your bylaws. Typically, the bylaws don't address this, or the bylaws typically follow the statute and they say the rest of the board gets to decide who's going to fill that spot. Sometimes there's weird language where it says you kind of have to have a mini election for that spot, but typically it's up to the rest of the board members. And interesting, fun little, again, trivia fact, that's even if the remaining directors constitute less than a quorum. So if you're one of those sort of fluke situations where you have a board of only 3 and maybe 2 people resign, now you're stuck with only 1 board member. That's not quorum. How does the board function? What do we do? Well, that one person, this is the only time that one person on the board can appoint someone. So we have 2, and now we have quorum. Now we can function. Now those 2 can appoint the 3rd. And there we go. Now we're back up and running. Or you can hold an election to fill that vacancy if you really want to. Sometimes we get to a point where you do have the two that are left on the board and they can't decide who should be on that third spot. And it's a 1-1 tie. So how do we break the tie? Maybe you have an election to fill that vacancy. Why not? All right. Board of directors, let's get into that. So hopefully you guys know when you're on the board, you have a fiduciary responsibility to your owners. It's not quite the same as, a lawyer-client relationship, but similar in that you now have to be thinking about your owners, your community over your own personal, desires and intent. So putting sort of your community above your own personal interests. Now, the other part of this is you have to act reasonably. And there is a reasonable business judgment rule that protects you from personal liability, from, attacks and lawsuits, and again, liability associated with any of that, for any personal behavior that, or any behavior you do personally as a board member. If you are acting reasonably and you are exercising reasonable business judgment, you will be protected. Now, really what that means is if somebody else in your situation would act the same way, a reasonable person under the same circumstances, then you're going to be protected. If you're doing inappropriate things that we've touched on before, or you're taking bribes or you're taking kickbacks, well, then you're not going to be protected. And obviously, for good reason, you might be exposed to some liability there. But if you're acting reasonably, doing what you're supposed to be doing as a board member, exercising your due diligence, you're going to be protected. Now, that even means if you make a bad decision, so to speak, maybe as a board, you pick a vendor that then ultimately goes under, and it costs you guys money and you have to, start this project all over again, and you're behind schedule, and new contractor is going to be more, and whatever it is. And the owners might be mad at you. You guys screwed up. You made the wrong choice, whatever it is. If you did your due diligence, well, we can't predict that contractor was going to go belly up. We got our bids. We talked to their references. They did a great project for our, neighboring community across the street, and they just happened to go under. That doesn't mean you did anything wrong because you picked the wrong vendor or you made the wrong decision. Now, again, there's a different set of circumstances where if you don't do all of those things with your due diligence and you just picked that guy because he was, the brother-in-law of your treasurer, now we have a different situation there. So all of this is basically, were you acting reasonably? Were you exercising your fiduciary duty? And you'll be protected if you are. If you have any questions about any decision you're making as a board member, talk to your counsel. Make sure the board is relying on its expert opinions. That's your best, bet for being protected. All right. Board meeting notices. All your board meeting notices should also have the date, time, place, and you have to have all of the agenda items listed on your board meeting notices. Now, most of your board meetings are only going to be a 48-hour notice, unless your bylaws provide something otherwise. Your notice has to be posted on in the community at least 48 hours before, except in an emergency. And there are limited times where you're actually going to have to do a 14-day notice for those board meetings. Again, look at your governing documents, make sure the bylaws don't say something different, but occasionally you might need a 14-day notice. If you're adopting e-voting, if you are adopting a special assessment, that's a big one. You have to do a 14-day notice. If you're adopting any rules that involve lot use, you're going to need a 14-day notice. Then they have to be mailed, delivered, transmitted to all of your owners, and you would have an affidavit for that. You also may adopt some rules about putting notices on your website. Keep that in mind. Let's see, your notice this is another way to do it. The notice may actually have a hyperlink to your website or to the app. If you guys use an app instead of a website, they're all sort of one and the same, basically just an electronic platform to look at your documents. So, like we said, effective last year. So, and this gave you till January 1st of this year, an association that has 100 or more parcels has to have a website or an app. Now, again, website, app, it's all sort of the same. Make sure you basically have some electronic platform where your documents are going to be, where these notices are going to be posted, where people can go to find, again, a copy of your declaration, whatever it is. Member participation at board meetings. This is similar to what we talked about before when we were talking about membership meetings. Essentially, owners are allowed to participate in board meetings too. There are exceptions. You can have essentially two different kinds of meetings where you're not going to have to include your owners, and you wouldn't have to have it open and let them participate and all of that. All of your meetings, though, are supposed to be open, except for the following two: meetings with the board and its attorney to discuss pending or proposed litigation. So that's important. It's not just, hey, we're going to talk about a lawsuit, and so we're going to close this meeting. Your attorney has to be present, either on the call, on a Zoom, whatever it is. Attorney has to be there, and you have to be talking about pending or proposed litigation, or meetings that are held for the purpose of discussing personnel matters. Those are the two exceptions. Those are the two times you can have a meeting and it's going to be closed. It doesn't have to be open to all of your owners. We still suggest that you properly notice it, but you should notice it as a closed board meeting. Do it with your 48 hours, have the agenda item be, discussion with counsel regarding pending litigation. And you don't have to actually put, about the Smith litigation or something like that, but have an agenda item, do notice it properly, but then you can indicate that it's closed and owners are not going to be able to attend or participate. Other than that, your owners have the right to attend. They have the right to speak. You can adopt reasonable rules. We already talked about that a little bit. Recording handicapped access. You can adopt rules about recording. Also, your meetings really must be held at a location accessible to physically handicapped persons. If a physically handicapped person is going to be attending and they've asked that. Compensation. This is a kind of a funny one because, again, I know you guys are all in this for the money, right? I know how this works. You volunteer, you signed up for this job to do all this work for free, essentially. So you may not directly receive any salary or compensation from the association for your performance as a director, unless and except for the following: participation by such person. Let's see. So reimbursement for out-of-pocket expenses, that's one that comes up sometimes. Maybe you're going to have a meeting, the office copier goes down and you need to run to Kinko's and make a whole bunch of copies of some paperwork, and Mary pays for them. You can reimburse Mary for all those copies. Recovery of insurance proceeds, that may be something that comes up. And then really the big one is any fee or compensation that's authorized in your governing documents, or if the owners vote to approve it for some reason. So please double check your governing documents. I have seen that once or twice where the bylaws will actually allow for some sort of, I don't want to say salary or compensation, but some little kind of bonus if you serve on the board. They try and entice people to volunteer, but it has to be in your governing documents. Otherwise, no. Again, you're not doing it for the money, right? You're not in it for the salary. And this is what we're worried about: kickbacks, because we want to make sure everybody is doing what they're supposed to be doing, and they are, exercising their fiduciary duty, and they're looking out for the good of the community, and they're not in it for themselves. So there's a clear kickback prohibition. Officers, directors, managers cannot solicit, offer to accept, or accept a kickback. A kickback is anything or service of value for which consideration has not been paid. And we hear it all the time. We hear the allegations. Well, we were thinking about, putting out bids to do the clubhouse roof. And lo and behold, our president just got a new roof on his house, and he's saying we should use the same company. Now, there may be nothing unsavory about that situation. Maybe that company did a great job for the president, and he is saying, well, they said they could do the clubhouse, let's put them into consideration. But you do want to make sure that it's not, hey, we're giving him the bid because he did the president's house. Obviously, that would be a whole different situation, and we could have a whole kickback problem there. And again, these are crimes. These are actual crimes now. If you violate that prohibition, it's a third-degree felony, subject to monetary damages, and an officer or director who violates this prohibition is immediately removed from office by the board. It creates a vacancy, and the board can fill the vacancy. Now, some exceptions: if you're a director, you can accept food to be consumed at a business meeting with a value of less than $25 per individual. they're gonna have to raise that at some point. $25 seems very minimum. That's like a cup of coffee and a cookie at this point. And then any service or good received in connection with trade fairs or educational programs. So, we do these seminars in person sometimes we're at these trade fairs, these conventions, all of that. There's a lot of swag and merch that people give out at those things. If you're a director and you take some of that, that's fine. All right, grounds for immediate removal. This is interesting. So I used to work at the state attorney's office back in the day, and I did some criminal work. So anytime I get to talk about criminal stuff, I get a little excited. Sorry. So director or officer who's charged by information or indictment. So essentially charged. So they've been arrested and there are formal charges pending either by information or indictment. So it does not mean a conviction. It means there are pending charges with any of the following crimes must be removed from office. Now, again, this makes sense. This is logical, but this is good to know. If there is a pending crime on this list, director is immediately removed from office. Forgery of a ballot envelope or a voting certificate used in an election, theft or embezzlement involving the association's funds or property, tampering with physical evidence. Again, that has to do with records inspections and basically destroying records or hiding records because you're trying to cover up your crime, obstruction of justice, or any criminal violation under the HOA Act. So anything else that's in 720 that's considered a crime. So if any of those things are pending by information, indictment, charged against one of your directors, they are removed from the board. The board can fill the vacancy until the end of the suspension or whatever it is. If there is a finding of guilt, or if the charges are resolved without, let me say it the right way, sorry, without a finding of guilt or without any sort of plea of guilty, nolo contendere, which means no contest. If there's a no contest plea, that's a technical thing where they're saying, I'm not arguing these charges. I'm not going to dispute the charges. It's almost like, okay, I accept, but I'm not quite acknowledging that I was guilty. If there's not a guilty finding or a no contest plea, then that director or officer can be reinstated on the board. So perhaps it was all a big misunderstanding and the association learns that the state attorney's office dropped the charges altogether. If that's the case, director gets to be put back on the board. If a criminal charge is pending, the person may not be appointed or elected to a position as an officer or director of any association and may not have access to the official records of any association except pursuant to a court order. So that's interesting because you might be in one of those communities that has multiple associations, maybe a sub and a master, and maybe there are pending charges related to one, that person might be on the board of two associations. We have that, happen fairly often. We have board members or they own multiple properties and they're on multiple boards. So if you have this pending charge, you can't be on the board of any association. So kind of smart because again, we're trying to protect these HOAs from this kind of behavior. A director who becomes more than 90 days delinquent in the payment of any fee, fine, or monetary obligation is deemed to have abandoned his or her seat on the board, and by operation of law, they are off the board and the board can fill that vacancy. Now, this is an interesting one. It sounds kind of simple, but it gets a little complicated sometimes. To run for the board, so to be a candidate, you have to be current. You cannot be even, a day behind, essentially. Once you're on the board, you have a little window of grace period here. You can get a little behind, but once you're more than 90 days, you're done, you're off the board. And again, that's by operation of law. The law says, the statute reads, it's deemed that you have abandoned your seat. Now, if the board then gets, an email from John the next day and he says, oh, I didn't realize my check got lost in the mail. Okay, I brought the check to the management office, so I'm back on the board, guys. No problem, no harm, no foul. I'm here. I'll be at the next meeting. Now, if that's day 100, let's say, John has been removed from the board. Just because he now shows up and has the money does not mean you have to put him on the board. He is not automatically back on the board. He does not just automatically get his seat back. If you guys are okay with that, the remaining board members, you didn't even fill the spot anyway because you didn't have time and your board meeting wasn't until next week, and John's been a great board member. We have no problem with him. great, appoint him back, put him back on the board. If John has kind of been a thorn in your side, he wasn't really helpful on the board anyway, and we were really trying to we were hoping we could really appoint Bill, then you can tell John, sorry, John, too bad, too sad. We're filling the vacancy with somebody else. You don't get your seat automatically. So up to you, remaining board members. But interesting, we've had that come up a couple times. Conflict of interest disclosures. This is also sort of part of the same, movement we've been talking about this whole time. We want to make sure there are no conflicts of interest. That goes into kind of these, backroom dealings that we've had in the last couple of years. So we want to make sure if there is some sort of conflict of interest, it's disclosed, the owners are aware, and the board is moving forward without an issue. Now, essentially, if there is a conflict of interest for a director or officer, they are supposed to disclose this to the association at least 14 days before they're voting on the issue or entering into the contract that would be the subject of that conflict. There's a rebuttable presumption of a conflict if any of the following occurs. If it's a director or officer or a relative of the director or officer who wants to enter into a contract for goods or services with the association, or they hold an interest in a corporation, entity, whatever it is, that wants to enter into a contract with the association. Now, in a vacuum, that makes sense. Okay, so Bill, our new vice president, he owns a landscaping company, or maybe Bill's wife owns the landscaping company. And we're looking for a new landscaper anyway. And, they're the best landscaping company in all of Broward County. So why wouldn't we see if, Bob's or Bill's landscaping company can work with us? Well, because now it sounds like there's a conflict. He has a financial interest. He's on the board, all of those things. It doesn't necessarily mean that you can't do it. It doesn't necessarily mean that it's, a bad idea, because maybe they are the best landscaping company in Broward County. It just means we have to take some extra steps to make sure this is done properly, to make sure we've disclosed it, and to move forward. So if there's anything that you think could be perceived as a conflict of interest, talk to your counsel before you sign that contract with, Bill's landscaping or Bill's wife's landscaping company, because you want to make sure this is done properly and your owners aren't going to have an issue. So essentially, you would follow this procedure. It's sort of a special procedure for a board meeting, but ultimately you're going to have a board meeting to vote on this contract. It would have to be approved by 2/3 of the directors that are present, not just a majority, 2/3. And ultimately, Bill in that case should not be voting. Bill, should leave the room when they're deciding what to do there. And the contract has to be fair and reasonable, which hopefully if the board's voting on it, that would be the case anyway. And at the next membership meeting, that contract has to be disclosed to the membership. And possibly a member would have the right to make a motion to cancel that vote or that contract by a majority vote of the members at the next membership meeting. Now, again, if you remember, we said membership meetings are very rare. You typically have one a year. It's usually your annual meeting. And again, maybe you don't even have quorum. But if you've already entered into this landscaping contract and now 10 months later, you're at a membership meeting, it would probably be silly. And typically we don't see owners who realize they can make this motion and that they do anything about it. But it is there. It is in the statute. So just be aware. Official records. Okay. I feel like official records are slowly becoming the bane of my existence, and official record requests are really more the issue. Official records, hopefully this is not news to you guys. You have to keep your official records. Your management team hopefully is keeping these for you and keeping you organized. We won't go through the whole list, but if really your official records should be all of your governing documents, all of your insurance policies. There's a whole lovely long list here. It takes up, 2 whole long slides. Any written records, the bottom line here is that last catch-all, any written records of the association that are not specifically identified, which are related to the operation of the association, that's what you need to make sure you're keeping all records. The association has them. For the most part, you're keeping everything for 7 years, unless your governing documents require otherwise. Bids are only going to have to be kept for 1 year, which makes sense because they otherwise would sort of take up unnecessary space. Now, the other part of this is new provision, newish provision as of last year. Association must adopt written rules governing the method or policy by which the official records are maintained and how they're going to be made available. If you're going to have everything on your website, that sort of thing, hopefully you already have a policy in place of how you're doing all of that. Official records that are not accessible to members, records that are protected by attorney-client privilege or work product privilege, those are going to be part of your official records. You're still keeping them, you're still holding on to them, but they're not open for the owners to inspect. That makes sense. If you have pending litigation, you can't have your owners, you know, learning everything about what's going on when that's not for them yet. This is an interesting one. This comes up sometimes. Information obtained in connection with the approval of a lease or sale or other transfer of a parcel. Now, if you think about it, it actually does make sense. When we do those applications for sales or for transfers and the board is reviewing these applications, there's very sensitive information on those applications. You might have full social security numbers, you know, addresses, names, driver's license numbers. So you're running background checks potentially. You have credit scores, you have banking information, you have, you know, a copy of a check on there potentially. All of that is supposed to be, you know, part of your application process, all well and good, but that's not going to be open for your owners to inspect during an official records inspection. So when you look at it that way, it makes a little bit more sense, but we do have sometimes owners that want to see every lease application that was denied in the last year or something like that. That information is not going to be available to them. They can't go through those applications. Information obtained in a gated community in connection with guest visits to owners or residents. That was also sort of a safety security addition that was added a couple years ago. If you have a log of everybody who comes, you know, through the gate, and you know that, you know, these guests are coming to visit your owners, whatever, however frequently, that's also information that you can keep. It's part of your official records, but not open to your owners. And then, like I said, any personal identifying information that you may have, if you have social security numbers, driver's license numbers, credit card numbers, all of those types of things, those are not going to be open for inspection. You should not be giving those to your other owners to see. And now ultimately, if there's information that owners get when they do their records inspection request, and then they transmit or email blast to the rest of the community, the association is not going to be held liable for that information coming out if an owner does something with that. And we've had that, you know, information happen before where somebody wanted a, you know, a log of the current, whatever it was, the AR report, the delinquency report, a current ledger, whatever it was, those would be open for inspection. And then they made, you know, a flyer that said, you know, Mr. Jones is a bum. I can't believe he just got a new Jaguar when he owes the association $6,000. Here's a copy of the ledger, and email blasts a flyer out to everybody in the community. The association's not going to be on the hook for, you know, by Mr. Jones being mad that that information got disseminated. Mr. Jones can take it up with the owner that did the records inspection and that blasted that information out. Other records that are not going to be available to all the owners, personnel records of your management team or the association employees, any of that. Now, that's different than your management agreement. So if you have an agreement with the management company, that's open for inspection. You need to keep in mind your owners want to know where their money's going. So that tracks when you think about it that way. But in terms of personnel records, your owners don't need to know that, you know, Eddie, the maintenance guy, you know, his records in terms of how much he, you know, his tax returns and whatever else and his personal information. They don't need to be seeing that. Medical records of any owners or residents. You may have, and you may say, why in the world would we have any medical records of anybody? You might, because you might have a request from someone to have a reasonable accommodation or a reasonable modification. Maybe they have an emotional support animal in the community and you're a no pet community. Maybe something along those lines. It could be a million other things. But if that's the situation, you might have medical records. They may have given you something from their doctor or whatever it was, and you need to make sure that information is not open for inspection, and you're keeping that in sort of a separate area. Any electronic security measures that you have, passwords, safeguards for data, all of that obviously shouldn't be open to owners. Any association software and operating system information, that should also not be open to owners. There you go. Attorney-client privilege, we talked about that. Really, that has to do with, you know, again, pending litigation, proposed litigation, any guidance you get from your attorneys. When we send you emails telling you we think, yes, you should do this, or no, you shouldn't do this, and here are the risks, all of that, don't share those emails with other owners. Those are meant for the board, only the board. The board can waive the attorney-client privilege, but generally we're going to tell you don't do that. Don't do that. Talk to your attorneys if there's something that, you know, if you want the attorney to give you an opinion that you can share with the owners, that is very different than, hey, attorney, can you tell us what you think about this? And then you're going to email it, blast it to everybody. If it's going to the board, it's going to be a very different opinion, you know, that I write versus if I'm giving it to the board, knowing it's now going to be sent out to the community. So make sure to talk to your attorney if you have a situation like that. Membership directories, you can actually print and distribute a directory with the name, lot, address, telephone number of each of your owners if you'd like. That's sort of, some communities still do that, but it does seem to be less so now. An owner can exclude their telephone number from the directory if they request that. We want to let people sort of opt out if they don't want their information out there. And they can also consent. So you want affirmative consent from an owner if they want contact information that wouldn't otherwise be open. If they want to let the owners, you know, if they want to publish their email address, but they actually haven't opted in for email notices, they could give an email address if they'd like. That's great, but let them opt in. Providing rules and covenants. So this was a new one last year. So hopefully you guys have already done this before October 1st of 2024. An association must provide a physical or digital copy of the rules and covenants to every member. Association must provide those things to every new member too, as you know, going forward on a regular basis here. That shouldn't be a surprise. Your management team should be helping you with that as well. Anytime rules are amended, the association has to give the owners an updated copy so that the owners know what the rules are and what the covenants are and what they're supposed to be doing. You can also comply with this requirement by posting those rules and covenants and all that on your website, or a direct link on the homepage, and then that takes you there. So keep in mind, hopefully that's something you guys have already done. Access to official records. So like we said, the whole part of, you know, official records being a little bit of a pain is because you have to give access to the official records, and that alone is not a problem. It's just the logistics of responding to the requests and, you know, the administrative time of going through everything and sitting with an owner and all of that. We all hear it, we all know, but it is something you have to do. The statute allows it. If you're an owner, it's a right you have, is to inspect the records. So this is something we all have to deal with. And again, your management team hopefully, you know, is very familiar. It's something they deal with regularly. So records have to be made available for inspection and for copying by an owner within 45 miles of the community, within the county, within 10 business days of receipt of the association of the written request. So 10 business days, that's your window. It's not a lot of time. It's 10 business days, so it's not 10 calendar days, which is nice. That gives you a little bit more time, but it's not a lot of time. You have to make sure you timely respond to this request and you offer that access, and you provide them the opportunity to come in and inspect records if that's what they want to do. Another way you can do it though, now you can have a copy of the records available. You can make them electronically available. So that's one way to do it. You can send a link to all the records that they want to see. Or if the records are on your website, you can respond, great, everything you've requested to see is on our website. Here you go, here's the link. That's one way to handle it too. Now, and that was sort of a recent change, even though that was something that makes sense. But make sure if you get a request to inspect records, you're treating it, you know, you're addressing it timely, because that's a big thing, 10 business days. And there is a potential penalty. So if you don't respond, if it's a certified mail, return receipt requested, and you don't respond timely, there's a rebuttable presumption that the association willfully failed to comply. And a member who's denied access is entitled to actual damages or minimum damages for the willful failure to comply. And that can be $50 per calendar day, up to 10 days, and potentially even attorney's fees. So you want to, again, respond timely when you get a request for official records. Now, this is another one, and this is going to sound very funny, but it was part of the new laws last year. So we have it in here. We have a slide. And once I read it and tell you what it was for, you'll know. If the association receives a subpoena from law enforcement for records, the association must provide a copy or make those records available within 5 business days after receipt of that subpoena. The association must assist law enforcement agency in its investigation to the extent permissible by law. So law enforcement can issue a subpoena, and then that means it's not a normal business, 10 business days because it's a records request. No. Subpoenas get, fast tracked. It's law enforcement. So you have 5 business days to respond. You have to cooperate with law enforcement, the board, the association, management, everybody. Now, again, based on, I think, what we've already covered and the tenor of some of these changes in the last couple of years, that's why this was put in there, because we want to make sure our associations are doing what they're supposed to be doing and that our boards are not committing crimes and not stealing money from the owners. And obviously, if law enforcement needs to investigate, we want to make sure everybody's cooperating. All right, more crimes, guys. Official record crimes. Any director or manager who knowingly and willfully, repeatedly, 2 or more violations in a 12-month period fails to provide access to the records, the intent of causing harm, commits a second-degree misdemeanor. I don't love this one. This one makes me a little nervous the way this is phrased. We want to make sure, again, you are timely responding to any records requests so that this never comes up. But you need to be careful. You need to make sure there's no allegation that you're, improperly denying access, because you don't want to be on the wrong side of someone alleging now you've committed a crime because it happened more than once in a year. If a person knowingly, intentionally defaces or destroys accounting records, again, this is all sort of because we're assuming people are trying to cover up crimes already. If they refuse to release or produce association records with the intent to avoid or escape detection, arrest, trial, punishment, or somehow otherwise assist a person with avoidance, escape, commits a 3rd-degree felony. So these are possible crimes related to official records. Again, get with your counsel as soon as you get anything that resembles a request for official records. You can adopt rules regarding official records, how they're to be inspected, all of that. You can't require that the owner show any proper purpose for their inspection. You can't say, hey, well, why does Mary want to see the special assessment meeting notice from last year? She's already paid the special assessment and she shouldn't care. Doesn't matter. If she wants to see it, you can't ask her why. Doesn't matter why she wants to see it. She's entitled to see it. Require an owner that state any reason, same thing. Can't ask them, doesn't matter. Can't require that as part of your rule. And you can't limit an owner's right to inspect the records to less than 1 8-hour business day per month. That's important because you will have, boards, management teams that want to offer, hey, you can come into the office for an hour and go through the records and then we're done, right? Well, your owner might want to go through all of the official records. Can't do that in an hour. You definitely need to be able to give them at least 8 hours in 1 month. So maybe you make an appointment, and you give them a 4-hour window. If they take up the whole window, we schedule another one, or they come in for 2 hours and then we agree to, keep continuing and scheduling appointments for them. But you can't just say, well, you were here for 2 hours, so we're done. Not how it's going to work. Copy records or copying records and fees. Obviously, if someone comes in and they want to take the pictures and scan, or, they have a portable scanner of their own, great. If they want to take pictures with their iPad, with their iPhone, you can't charge for any of that. You guys didn't do anything, so you don't charge for that. If they're going to use your copier, maybe that you have in the office, then you can charge. You can charge up to 25 cents per page if they're using your copier. If you don't have a copier available, or if they're trying to make copies and it's going to exceed 25 pages, you can require that they sort of tab the pages and you can send it out to an outside service or to an outside copier. And you can charge back the actual cost of those copies to that owner. I would ask for that invoice before you give them the copies, but obviously you should have the invoice from the vendor. So you already know, oh, this was $20 worth of copies or whatever it is. But you're just going to get, again, whatever the cost was. Now, personnel costs, this is an interesting one. You can actually charge costs for the time for the personnel to retrieve and copy the records if that exceeds 1/2 hour and if the personnel costs do not exceed $20 per hour. So this is not a money-making thing for the association by any stretch of the imagination, but you might recover a little bit of, your fees a little bit. Personnel costs can't be charged for record requests that result in copying of 25 or fewer pages. So if that's the case, too bad. It's just a cost of doing business for the association. And again, I hear the complaints all day, every day, that this is such a burden on our management team. It costs our admin team, so much time, and they could be doing other things and all of that. And I understand it. And that's why we also tell you to maybe get some things on your website, get that going so that you don't have to sort of do these inspections in person like this. All right. Association website. Well, I was just talking about that. Look at that. So by January 1st of 2025, so, 6 months ago or so, 100 or more parcels, you're supposed to have a website or an app, and you can post these documents. Now, all of your official records don't have to be on the website yet. Statute doesn't quite mirror the official records. But again, maybe you want to think about doing that just to make your lives easier so that you can direct everyone to your website when you get those official records requests. So the way the website works or the app works, again, those are sort of one and the same, just an electronic portal of some sort that you can access through your phone, through an iPad, through the internet, through a computer, whatever it is. And it has to be protected for your, for your owners. So you're not putting everything out in the open for anyone under the sun to Google you and to look up all of your information as an association and to access all of your documents. But you're going to give your owners a username, a password, so they can access some of the, protected sections, some of those things. Some of your stuff, you could have open to everybody and maybe, it doesn't matter. Maybe a copy of your deck or whatever it is. Who cares? That's public record anyway. But you wouldn't want, your financials, that kind of thing, open to everybody under the sun, only your owners. So again, the documents that you're required to post, they don't quite sync up to the official records. The list is here. Take a look, make sure you're compliant. All right. Now, any records that are not accessible to owners. So we talked about official records that wouldn't be open to your owners. So any attorney-client privilege, anything involving, information received from leases, sales, that kind of thing, medical records, those things cannot be posted on your website. So you want to make sure those things that were supposed to be, separate and redacted and not open to owners, make sure those are not on your website. Or if they are, again, if they're just redacted, if they need to be. And maybe, again, you have some information that has some sensitive information, the personal identifying information, that should just be redacted off of those documents before they're uploaded or posted to your website. All right. Amending your governing documents. This is a topic, we have a separate class on this all by itself, where I talk about amending your governing documents for a solid hour. And so I won't do that today because that would put us a little behind schedule here, but we'll talk about it briefly. Amending your governing documents is something you might want to consider doing, is the bottom line. Your documents were probably written by your developer some years ago. Maybe they've been amended through the years. The problem is you may have a hard time getting them amended, and that may be because of your amendment threshold. If you have a large number that you have to overcome to get your owners to approve any amendments, you're going to have a hard time. I know. So if your governing documents don't say anything about amendments, what kind of vote you would need, the sort of default is 2/3 of your voting interest would have to approve it. A lot of governing documents just have that language anyway, 2/3. Some of them have even 75% of our owners need to approve amendments. I would say before you do anything, again, this isn't really legal advice, it's educational, but my 2 cents, look at your governing documents provision, see if you want to do any amendments. Step 1, amend your governing document amendment provision and bring that threshold down. So if you have 2/3, if you have 75%, bring that threshold down. I don't know what makes sense for your community. You would know better, but maybe a majority. If you could do it even lower, if you could get it to, a majority of those who vote at a meeting at which quorum is obtained, Now you've really significantly lowered that threshold. Now it means we need quorum. So we need our 30%. We'll use that number. We need 30% to come to a meeting, and the majority of those who vote would approve an amendment. That's a very different number than a straight majority of our whole community. Now you might have a community that gets a little, a little suspicious, a little paranoid. That's not enough for them. If you want to do just a majority of everybody, maybe that's a better number. But again, start there before you do any amendments. That's number one. If you have 2/3 or 75%, it's going to be real hard to get some amendments passed. And then you're just going to be sort of spinning your wheels here. There's a specific procedure, the way the amendments are supposed to be formatted. You're supposed to underline all the new language, strike out the old language, essentially so that when your owners are reading the amendments, they understand what the changes are that you made, kind of like redlining, but without actually being read. If you are changing a section entirely and it would just be, pages of strikeouts and pages of underlines, there is language that allows you to say that there's been substantial rewording, see the current governing documents, and you don't have to type out all that stuff again. You also want to look into whether or not your declaration requires lender consent. Sometimes there's language in there that says your banks have to approve, any lenders are going to have to approve a certain amendment or an amendment that impacts their interests in some way. And that's less of a hurdle than it sounds like now, because realistically, we know that you're not going to get a yes, I approve from Bank of America. That's never happening. But there's a process in the statute where you can do a negative notice, a mail out. If they don't respond, they've deemed to have consented. But that's something to look at too. That's something to factor in if you're thinking about doing amendments. If you were to amend something and you needed lender consent. Amendments are going to be effective on the date that that amendment is recorded in the public records. So it's not just the day of the meeting. If you have all your owners approve a proposed amendment, tonight at the meeting, tomorrow you can't say, well, we approved now that we are whatever, a no pet community. Tomorrow, no pets are going to be allowed in. Well, it needs to be recorded first. So it's the recording date that starts the sort of the clock running. And you have to send copies to your owners. Anytime the governing documents are amended, you have 30 days to send them a copy. Now, realistically, if they were given a copy in advance and nothing has changed from the amendment that was actually recorded, you can just send them a notice that it's been recorded and a reference to the instrument number of the book and page, and they can look it up themselves. You don't have to do a whole new mailing. Maybe if you were doing an amended and restated deck, that could be a 100-page mail out you'd have to do again. So they saved you a little money there. All right, some other sort of miscellaneous topics that we'll just touch on. We're going to get into some of these. Governmental filings. Essentially, even though, again, you're an HOA, things are a little different for you. You have 2 governmental filings that you have to do every year. One is with the Division of Corporations. That's, sunbiz.org. That keeps you in your active corporate status. You want to make sure you don't default there. You have to file that annual report. If you do it late, you have to pay an extra fee, but ultimately it's a filing fee. Income tax, annual income tax. And I know we get this question, but wait, we don't have income. What are you talking about? Talk to your accountants. Odds are you still have to file an income tax return. And because you do get income, you do get estoppel fees. Maybe you have something else going on. Maybe you got a cable deal and the association got some money from a cable company or whatever else, or maybe you're renting out the clubhouse for a cell tower or something, and you're getting income every month. Talk to your accountants, make sure you're complying with that. Meeting minutes. Minutes don't have to be a verbatim, transcript of the meeting. That's important because we have owners that want, every single word to be transcribed, and I want it on the record that I said blah, 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 blah. Well, the record isn't really all of that, realistically. Your meeting minutes are supposed to record, who was there, what the motions were, who seconded the motions, who voted, how they voted, that there was discussion, but it doesn't necessarily have to transcribe. And then Mary said she thinks it would be a good idea if we painted the clubhouse pink. And then Joe said he doesn't think it would be a good idea. You don't have to do that in your minutes, okay? What's a material alteration? Material alterations are a hot topic nowadays, but now for HOAs, that's not really something that comes up as much. Condos, it's a little different. 718 has a whole provision about material alterations and a vote that would be required by your owners. Now, the thing that does transfer, I guess, so to speak, is what a material alteration is. The definition of a material alteration came from a condo case, and we use the same definition because it's the only one we all have. And it's a very silly sounding definition, so don't get mad at me because it comes from the case and it sounds ridiculous, and I am going to read it word for word. So, as applied to buildings, the term material alteration or addition means to palpably or perceptively vary or change the form, shape, elements, or specifications of a building from its original design or plan or existing condition in such a manner as to appreciably affect or influence its function, use, or appearance. So, nice clear-cut definition, right? Easy, simple, everyone gets it, nice and black and white. No, strange, weird, we get it. What actually qualifies as a material alteration gets a lot more complicated. There's a lot of gray zone in there. You know, hey, we're painting the clubhouse from beige to white. Is that a material alteration? If we change it from white to pink, is that a material alteration? If we decide we want to change one of our tennis courts into a pickleball court, is that a material alteration? But we're not actually changing anything. We're just moving the net down, or we're going to paint new lines. Does that change anything? All of these things are, you know, factual considerations, case by case, talk to your attorneys. Some of them are much clearer. Hey, we're going to knock down the clubhouse and, you know, whatever, build a pickleball center. That would be material alteration pretty clearly. But whether or not you need a membership vote to do that is really what the question comes down to. And for most HOAs, you probably don't. You want to check your governing documents. This is where governing documents come in very importantly for HOA world, okay? Governing documents, when we're talking about material alterations or a capital expenditure or anything like that, 720, chapter 720 does not address material alterations. Condo world, it's in the statute. In 718, it's in the statute. It is not in 720. So this is one of those big differences between condo world and HOA world. Your governing documents are going to control. So you might have something in your governing documents that says, you know, the board cannot incur or cannot improve the property and incur an expense of more than 10% of the annual budget without approval of the membership or without the vote of the members, without a majority of the members voting in favor of that thing. Or the board cannot spend more than $50,000 on an alteration without a vote of the members. But your governing documents might not say that at all. They might say the board can do it, because typically those types of decisions would be a board decision. Whether or not the board can, you know, do something that's involves maintenance for the community typically is a board decision. But if it qualifies as a material alteration or some sort of capital expenditure, or maybe if it's going to involve a special assessment being adopted to fund this thing, you know, hey, we're going to do this whole renovation project. We're going to paint the clubhouse. We're going to change the pickleball courts. We're going to do all this stuff. And by the way, there's going to be a special assessment against every lot to fund that. Then there could be language in your governing documents that say only if there's a special assessment adopted to, you know, fund such a project, a majority of the owners have to approve it too, or you know, 60% of your owners have to approve it. You want to be very careful, and you want to look at your governing documents, because there's a million variations and alterations or variations of what an alteration could look like in your governing documents. And it could or could not require your members being involved. You may or may not need a membership vote for that. So look into that before you make any big changes and before you spend any money. Rules and regulations, generally, your governing documents are going to give you permission for the board to adopt rules and regulations about use of common areas, use of your rec facilities, your amenities, all of that. But look at your governing documents, make sure that authority is in there to adopt rules. Rules are typically adopted by the board. So, you know, something that says, hey, the pool closes at, you know, 6 p.m., that's a rule adopted by the board, as opposed to a restriction that's in your declaration. If it's in your declaration, it's going to be adopted by your owners or approved by your owners, or it was put in there by the developer. But if it's just about the, use of common areas, it's probably a board decision. It's probably a rule that the board can adopt. But look carefully, because sometimes, again, there's weird language that requires that your owners get to veto the board's decision or something like that, or have to approve it. If there's a rule about parcel use, that's where it gets a little different too. That's a board member, that is a board decision, if it's a board decision, but it's a weird notice requirement. It's a 14-day notice as opposed to a regular 48-hour notice for that board meeting. Other than that, any other decision, that the board's considering regarding rules would be done at a regular 48-hour notice meeting. So if you're changing the pool hours from 7 p.m. to 8 p.m., that's a normal 48-hour decision, board meeting notice for that decision. If you're deciding we're, going to change the rules about which kinds of trees can be planted on lots, that's a 14-day notice. Ooh. All right.
A quick interruption. Since we're about the halfway point in terms of number of slides, for those of you who have not yet done so, press the chat button now. Press it one time, simply so it appears, because later on, that's where we're going to place the evaluation link for you to click. You fill that required evaluation out later. Then after that, there'll be a link for the slides, plus Emily's contact info and Associa's contact info. Back to you.
Thank you. Halfway through the slide. Well, this is where we get to the point where I'm going to skip a lot of slides, but all right, let's keep going. Marketable Record Title Act. You'll hear people say MRTA. To me, the MARTA is the, transportation system in Atlanta. So I just say MRTA because it's MRTA to me, but you hear both. What is important about this is, and this is only for HOAs, it's not for condos, your declaration of covenants. So it is binding on the land. It is a covenant. It is a restriction. It lays out these restrictions that are on the land that run with the land. Now, there's something in the statute, and it's not in it's referred to in 720 as well, but it's really 712 of Florida statutes that talks about how these covenants basically start to expire. So covenants will expire after 30 years, unless they're preserved or unless they're revitalized. Now, again, there's a whole process of how this should go, but that could apply to your declaration. This is why it's important. If you are in a community that is either coming up on being 30 years old or you're past 30 years old, you want to look into this and make sure your declaration didn't expire, or what you need to do to make sure your covenants are still active. So either there's a preservation process, that's a board meeting notice, board meeting process, much easier if that's within your 30 year window. That preservation process is much easier because it's just the board. If you're outside of the 30 years and your covenants have technically expired, we have to revitalize your declaration. We have to revitalize your covenants. That's a little bit more of a process because you need your owners to vote. You need to get a majority of all your owners to approve it. So there is there are a lot more steps that go into it, a lot more time and expense that goes into it. But that's something to look at. Again, we won't get into the details, but talk to your attorneys. And again, that's depending on sort of how old your community is and how old your declaration is. So look at that and make sure you guys are good on that. Emergency powers. We talked about this. This was really something that kind of came out of COVID. Basically, you have some emergency powers now in the statute. We don't need to get into too much of the details there. Debit cards. Interesting, weird change sort of to the statute last year. An association, its officers, directors, employees, agents cannot use a debit card issued in the name of the association for the payment of any association expenses. And they just say debit card, not credit, debit card. Cannot use a debit card. Because again, we were worried about all the fraud and alleged stealing and all that good stuff. Cannot use a debit card, not credit, debit card. But a person who uses a debit card issued in the name of the association for an expense that is not a lawful obligation of the association commits theft. So now we've made it a crime. And then there's an actual definition for what a lawful obligation of the association is. So, and that has to be pre-approved. So you can't retroactively approve an expense. So bottom line, don't use a debit card, period. Don't use a debit card. Okay, that's the takeaway from that slide. Litigation authority. This is interesting because this was something added to the statute that some people don't realize is in there. essentially, if you're in an HOA and there's the chance that you're going to pursue litigation where the amount in controversy is in excess of $100,000, so that's a pretty high threshold. The association, before the board can just move forward with this, the association must get approval from the owners. It's in the statute, you have to do it. So it's a majority of the voting interest present at a meeting where quorum has been obtained. So it's not a strict majority across the board. It's a majority as long as you get quorum, a majority of those who show up as long as you got your 30%, whatever it was. Now, that's again, maybe it's for a bigger lawsuit. So maybe you're suing the developer, maybe it's a 558 claim, something like that. It doesn't come up that often, but it's something you need to know about. Architectural control. This is something that comes up all the time for you guys. So we'll get into this a little bit more. We changed some provisions in the statute last year. HOAs were kind of a hot topic in 2024 for whatever reason, or I guess probably 23 to 24. There was, there's a little bit of a feeling that maybe HOA boards were being a little too strict, a little too aggressive, and you want to let homeowners kind of do their thing and give them a little bit more leeway. That seems to be a little bit of the mentality here. So people were concerned that these ARC sort of denials were not were happening sort of randomly, capriciously. The boards weren't being consistent with their decisions, or the ARC committees weren't being consistent. So this is what kind of spawned some of these changes. So now we've made it clear, association must reasonably and equitably apply and enforce the ARC standards and the published guidelines and standards that are authorized by the declaration. So bottom line, if you have ARC approval rights in your declaration, if you have a committee, or even if you have guidelines that just say the board is going to approve these things, make sure you have adopted clear guidelines and specifications, and they are published. Everyone knows them. They're, you might not have a provision in your declaration that says we only allow, not higher than 6 foot tall white PVC fencing, but that's something you would want in your specifications that said, that will say something like, we don't allow shadow box fences higher than whatever, or we don't allow shadow box fences. We only allow white PVC fencing, or whatever it is. Those little details of, your declaration may say, before any fence is installed, you must obtain board approval, or you must get ARC approval. But odds are it's not going to say something that specific. Well, do we allow chain link? How tall? Do we allow PVC? Do we allow shadow box? Are we allowed to do wood? Can we paint the wood? Is it PVC only? Is it, again, all of these variations, those specifications, those guidelines should be adopted in a policy. You should have these ARC guidelines so that owners know when they submit an application, what the board would approve, what the ARC is going to approve, what they won't approve. If you just say, hey, if you're going to put in a fence, let us know first, and we'll tell you whether or not we approve it. That's a wide range of options. Okay, so does it just mean you'll approve anything I tell you I want to put in? So that's where sort of this came from. We have to have these guidelines, we have to have these specifications really spelled out so people know what's going to be approved, what's not going to be approved. So now if the ARC or the association denies an owner's request, they are supposed to provide written notice stating with specificity the rule or the covenant they relied on to deny it, and basically the reason it doesn't conform. So again, if you just have a provision that says, fence installations have to be approved by the ARC, and you don't have any guidelines published, or maybe your guideline is only, hey, no fences higher than 6 feet. And then someone submits, okay, I want a white PVC fence that's going to be 6 feet. And you say no. Well, why'd you say no? The only restriction was no higher than 6 feet. And I told you this isn't going to be higher than 6 feet. So what's the restriction? Well, we don't like white PVC fences. Well, it doesn't say that in your guidelines. It doesn't say that anywhere. So these are the things you need to make sure, you're clear on. Now, association can't enforce a covenant or a rule or a guideline that, and bear with me on these guys. This is going to be, you might get a little frustrated if you're on the board side of these things. If a covenant or a rule or a guideline places requirements on the interior of a structure that's not visible from the parcel's frontage or an adjacent parcel, I have no problem with that. You're not going to be able to enforce that. If it involves specifications for HVAC systems or something, and none of that's visible from the outside, association's not going to be able to enforce that. Some of those sort of make sense. If it's something that no one else can really see, why does the association need to be involved? That was sort of the thinking here. This is the one that tends to frustrate people. Items on a parcel. So if your documents, if your covenants already have a restriction, again, we might get back into this whole Kaufman language argument. We're circling back to what we started with. Does our restriction that was in the covenants before have to now comply to the statutory change? Or does the statute not affect us and we can enforce the covenant we had before? These are all considerations you want to talk to your counsel about, see what your restriction was previously, see what the language is in your governing documents. But bottom line, now the statute reads, and this went into effect, a couple of years ago, and then they modified it last year. Regardless of any covenant or restriction, essentially, unless there's something in a local ordinance or whatever, the association may not restrict owners from installing, displaying, storing any item on the parcel which is not visible from the parcel's frontage or an adjacent parcel or an adjacent common area. We did add that in. So all those properties that, back up to a golf course or a lake or whatever else, or a street even, or a community golf course, including but not limited to artificial turf, boats, flags, vegetable gardens, clotheslines, and RVs. You can't enforce a restriction to remove those things unless they are visible, basically. So if you have a covenant in your declaration already that says no sheds in the rear of a lot or no sheds on the lot, but somebody wants to put a shed in the back of their lot and you can't see it from the front, you can't see it from the side, you can't see it from the back because maybe there's a fence or maybe there's hedges or whatever it is, they're on a corner, there's a preserve behind them, I don't know. Then now the question is, well, can we enforce our covenant that says no sheds? Or does this statutory provision that says we can't enforce that covenant because it's something we can't see from an adjacent parcel or the frontage, are we stuck? What do we do? This is where we get into that whole Kaufman analysis, like I said. So if it's something like that, talk to your attorneys. If you're considering doing amendments, be aware that if you do an amendment now, you may be kind of stuck because the statute is already in place. So if that's something that is a concern for you, if you're worried about people storing boats in their backyards, RVs, doing these things, sheds, that's a big one, like I said, talk to your attorneys and see, go from there. Hurricane protection, this was new. The association must adopt some hurricane protection specifications for each structure. We don't really need to get into that too much. Vehicle restrictions, this is one that comes up. This is similar to, again, that Kaufman argument, that Kaufman conversation, when we talk about, do we have to follow the statute or can we enforce what was in our governing documents? There is an argument that if you had a covenant that says no, commercial vehicles, you can enforce that and you're not subject to the change in the statute. But again, you have to make sure, see what the deal is with your documents, if there's Kaufman language, if there isn't. So the statute now, and this is only 720, not 718, statute now basically kind of gives a little bit of a runaround for owners who want to park their personal vehicle. That's the language in the statute, personal vehicle, which includes a pickup truck, in their driveway or in any other area in the community they'd be allowed to park. If there's additional parking, guest parking, something like that, you can't prohibit that in your governing documents anymore. So if you had language that, we don't allow trucks, whatever it is, and then this continues to also say a work vehicle, regardless of any insignia or design or whatever else. So again, if you have someone who maybe has, Joe's Roofing on the side of his pickup truck, and before you would have said, well, that's a commercial vehicle, it's a pickup truck, but it has some signs and whatever else, and we have provisions. You can't park commercial vehicles in our community. They can't be in the driveway. They have to be, in the garage. They can't be here overnight. You may or may not be able to enforce that now. It depends on the language in your governing documents. It depends on, again, the analysis with Kaufman language. But this has become a sort of a big hot topic now because we have a lot of owners who have come out of the woodwork and said, well, wait a minute. Now I get to bring my truck into my community and the association can't stop me. Well, that may or may not be the case. Depends on, again, what the restrictions were, if that covenant was in there before. So talk to your counsel if that's something that's coming up for you. Contractor restrictions. This was something new last year. This came up, I think, actually, I think I do know where this came from, but it's a little strange. So now the association's governing documents can't prohibit an owner from inviting, hiring, or allowing entry to a contractor or worker onto the parcel solely because they're not on a preferred vendor list of the association. So again, this is kind of goes with the whole mentality that they thought HOA boards were sort of overreaching and exercising too much authority and not letting their owners kind of do certain things. This falls into that category. Or because they don't have a professional or occupational license, you can't keep them out of the community, keep them off the parcel. You can't require that they present that license in order to be let into the community. That was a change last year. Budgets and reserves, we'll get into this. So essentially, we're not quite in budget season yet. It's coming up soon though. But the association has to adopt or has to prepare an annual budget. Typically, the board adopts it. Typically, it's not the owners that really get too involved. They're allowed to come to the meetings. They're allowed to talk about the budget. They're allowed to express their, frustration or suggestions as to, overspending on things or whatever it is. But typically, it is a board decision whether you proceed with the budget that you have in the proposed budget. Your management team is really going to help you with your budget. Realistically, your budget is meant to be just a good faith estimate of what your expenses are going to be for next year. Your operating, your reserves, those are the two main components. Those are the two parts of your budget. Typically, you just look at last year's budget and you adjust accordingly. Well, insurance went up this year, or maybe we're really lucky. We did the, clubhouse roof, so our insurance went down this year. Great. You can adjust sort of your budget accordingly. And base it on the prior year. Now, generally also keep in mind, funds that are in your operating section are not restricted to those line items. You might put in there that we need whatever it is, $50,000 for our landscaping and $10,000 for our, janitorial services of the clubhouse. But if that janitorial service needs more, you can take it out of that landscaping. That's fine. That's how you do your budget. Again, it's an estimate, but those line items are not locked into those purposes. Operating expenses, again, those are your day-to-day expenses, any of your management fees, admin fees, insurance, association, accountants, legal fees, all of that, maintenance, that kind of thing. Your reserves, it's a little different when we talk about reserves. Now, a lot of HOAs don't have reserves. That's not unheard of. That's not crazy. Don't be alarmed if your community doesn't really have reserves. That is, again, not this is again where HOAs and condos are a little different or a lot different. HOAs typically don't really have that many reserve accounts. It's just done a little differently than condos. The budget may include reserve accounts, typically for, capital expenditures. If it's something that's the useful life is greater than 1 year, that may be something they want to reserve for, because you kind of want to build up slowly but surely. Deferred maintenance, same kind of thing. Maybe pavement resurfacing, sidewalk improvements, repairs to the, again, common area, clubhouse, things like that, where you just figure, let's put away some money slowly but surely so we have this pot of money down the road. Now, if you want to create a reserve account, now you can also just, the board could be keeping this money, hey, we're going to probably have to repave in 5 years. Let's start putting some money away for that. The board can do that. They can start doing that. But now whether the statute requires that you be funding this, paving fund, it depends. Now, if a majority of the total voting interests vote to create a paving reserve or whatever it is, now you're sort of stuck with that and you have to fund that reserve. Again, if the board just decides on its own, let's put some money away for pavements or, or for the paving project, we want to have a slush fund. We want to have a contingency fund. We don't know if, that project we were going to do is going to go over, we're replacing the gate. We want to have a little extra money. The board can factor those in without it being a statutory reserve that requires funding every year. So keep that in mind. If it's established by the membership, now it's a statutory reserve, and now you're kind of stuck with it. Reserves that are set up by the members, or reserves that are spelled out in your declaration that the developer maybe set out, are statutory reserves that now you're stuck having to fund every year. Otherwise, you would need a vote. Calculating reserves, again, you're just looking at sort of what the estimated life is, what the cost is, and back it out mathematically. So changing use of reserves or pooling reserves, you can establish pooled reserve accounts. Like I said, maybe if you want to do sort of a contingency fund and it's going to cover a paving project, clubhouse renovations, pool, whatever, new pool furniture, whatever else, you could have a pool for all of those things and put all of those funds together. If you do have reserves set up that are statutorily created, the owners decided, they voted on, creating a paving account or whatever it is. And down the road, you realize, well, we want to do this clubhouse renovation. We have that money in that paving account. Those two things are not the same. It'd be easier if we could just use that paving money and then we could deal with the paving later on. If you now want to use that paving money for something else, you would need a membership vote. So that's something to consider too, as opposed to, really creating the statutory reserve accounts. And if you want them to be individual accounts or pooled reserves, all considerations, talk to your team. All right. Waiving reserves, reducing reserves, again, membership vote, you would need all of that. Adoption of the budget, like I said, typically this is a board decision. That means it's a 48-hour notice unless there's something different in your governing documents. That is different than condos. Condos have to send it out and they have to do a 14-day notice. HOAs statute doesn't say that. So your default is 48-hour notice. And again, the board gets to decide, not your owners. Again, look at your governing documents, double checks. Maybe you do have a strange requirement, but again, board decision, 48 hours. After it's adopted, you're going to send a copy of that notice out to everybody, or you'd send a note or copy of the budget or a notice that the budget's available to them at no charge if they'd like. Now, another part of this, if you're in an association with 100 or more parcels, as of January 1st of 2025, that annual budget has to go on your website. Because remember, now you have a website. Assessments and foreclosures. We talked about special assessments a little bit. It gets sort of sprinkled in. Bottom line, your special assessment is something that wasn't, factored into your budget. You either an additional expense, special project, something went over. You don't have the budgeted funds for these things. So you have to adopt a special assessment to fund this. Special assessment is treated the same as a regular assessment in terms of collections. It still can be subject to a lien. You can still foreclose, but you have to keep in mind to adopt a special assessment, you have to do it properly. It's very specific. There's a 14-day notice. It's going to be a board meeting. Again, unless there's something strange in your documents, maybe there's some requirement that the owners have to approve it for some reason. Maybe it's part of a material alteration or something. But other than that, typically it's a 14-day notice, board meeting. That agenda item has to indicate what the approximate amount of the special, so the estimated cost of that special assessment and the purpose of the special assessment. And the board meeting notice has to say, we're considering adopting a special assessment. So the notice is very important, and that 14 days is very important. And if you don't do that properly, you can run into problems down the road trying to actually pursue collections of the special assessment. So if you have any question before you adopt a special, talk to your management team, talk to your counsel, make sure you're noticing the meeting properly and you adopt it properly. Now, ultimately, it's up to the board in terms of adopting the special. Is it going to be a one-time payment of, $500? Or is the assessment something much larger? Maybe it's $5,000 and we want to break it up into 5 payments of $1,000 a month. You could do it monthly. You don't have to. You could do it quarterly if you guys are quarterly. Again, you don't have to. You could do it if you're a quarterly assessment kind of community. Maybe you want to do the special due on, those months that your quarter's not due, to break it up and make it easier for your owners. Lots of flexibility. It's really up to the board. Talk to counsel about the best way to do it for your community. This was a new change. Now there's a requirement to provide an accounting. Okay, strange, but stay with me here. So again, this was new last year. Parcel owner can make a written request to the board for a detailed accounting of the amounts he owes to the association, and the board has to provide that information within 15 business days of receipt of that request. once that parcel owner makes that request, he can't request another detailed accounting for at least another 90 calendar days. So they can't, inundate you with these requests. If you don't respond timely, there is a penalty. So if you get a request for an accounting, make sure you respond. Otherwise, 15 business days, it's a waiver of any outstanding fines that person might owe. So not a complete, zero balance. We scratch, every amount owed off the record, but fines. And this was because, again, there was a feeling that more owners were getting fined and they felt like they didn't know what they were even being fined for. And the board was being, a little abusive with their fining process. They didn't know, again, that they even got the notice, what the fine was for, how much the fine is, how much they really owe. This was the feeling in the last couple of years. So we've made some adjustments to the fining procedure too, but that's now the reason. So an owner can actually find out how much they owe. You have to provide this accounting. So your management team really should be aware of that. Now, collecting assessments, your assessments, that's your biggest tool, is really collections, because in theory, if you proceed with your collection efforts and somebody does not pay, you could take their home away. I mean, that is huge. So again, there is a whole procedure. There's a statute that lays out how many steps are involved. But bottom line, if someone doesn't pay their assessments, they could lose their home. And that is not a joke. And everyone says, well, but it's homestead, whatever. Nope. You could record a claim of lien against the property. You could foreclose that claim of lien. The person could lose their home. So it is important. Now, assessments, when they're not paid on time, the statute allows you to collect interest, allows you to collect late fees. You have to make sure this language is in your governing documents. You want to make sure you're able to collect the maximum amount allowed. So you want to, again, if you're considering any amendments, that's something you might want to look into, making sure you are getting the most recovery, the biggest late fee, the most in interest, blah, blah, blah. But that authority needs to be in your governing documents too. You can also collect attorney's fees that are incurred as part of the collection process. Now we're going to talk about the notice of late assessment, that, or you hear us sometimes say NOLA, notice of late assessment, NOLA. Ultimately, the way the NOLA works, and I'm not sure which slide it is, but we'll get to it in a minute. It's an additional requirement that was set up a couple years ago now, and it's all because some senator, representative, whoever it was, I don't know, didn't get his late notice. And then once he missed it, those fees, those attorney's fees, the collection fees, the interest, the late fees, all start to accrue. And suddenly, you went from missing an assessment and owing $500 to owing $1,000, pretty quickly. And apparently he was not happy about that and didn't think it was fair that he didn't get an extra notice. So now all of us have to send an extra notice, and it's a notice of late assessment, before any attorney's fees can be recovered by the association. So late fees, interest can still go on there, but that form, that notice of late assessment form, is laid out in the statute. You have to send it and give them 30 days to pay. It has to be statutorily compliant. You have to have an affidavit that confirms that you mailed it. And it has to confirm sort of two things. If that person's mailing address is the lot address, great. You have to confirm that you sent it to the lot. If that person's mailing address in the association records is different than the lot address, so maybe they're, sort of a part-time or a snowbird, or they own multiple properties, you have to make sure, and you have to sign an affidavit that says that you sent that notice of late assessment to both addresses, to their, home base in whatever, in Orlando, and to their, their condo down in Fort Lauderdale, whatever it is. So mailing address and lot, and you have to sign an affidavit that says you did that properly. So it's a notice of late assessment. You give them 30 days to pay, can't collect attorney's fees during that period. Once that expires, send it over to your attorneys, and now the attorney's fees can start to accrue. Collection of assessments generally, the statute also lays out how these payments are applied. Ultimately, the payment is applied first to interest, then the late fees, then the attorney's fees and costs, that sort of thing. And last is your delinquent assessment. So this confuses owners because sometimes they'll say, but I made June's payment on time, so why am I getting a late fee for the June payment? Well, you're running a balance from January. So June's payment was not on time because you're still running a balance from January, and we're applying these payments that are made in the order that the statute says we can. So you're going to get late fees every time until that account is paid in full. So things like that get a little confusing. Collections can be a little confusing. Make sure you have, you know, a good attorney working with you on that, so you guys can maximize your recovery and not take too long. Notice the late assessment, that's what we talked about. Liens and foreclosures. So bottom line, once you do that notice of late assessment, and again, typically that's done before it gets to our office. Once it comes to our office, now we have to send a first notice that gives 45 days to pay before we're going to record a claim of lien against the property. Once we send that notice, we record a claim of lien, 45 days comes and goes, the owner doesn't pay. We send another 45-day notice that says, hey, we're going to foreclose this claim of lien unless you pay. You have another 45 days to pay us. If you don't pay, we're going to foreclose. So notice number one, 45 days to record a claim of lien. Notice number two, we're going to foreclose that claim of lien. So potentially you have two notices, 45 days each, before you get to foreclosure when you actually file a complaint. Now, again, some days from mailing, some days from the transition, all of that. You're at a pretty big, you know, span of time before you get to actual filing of a lawsuit foreclosure action. So we always tell our clients, you know, be aggressive with your collection policy. Yes, you can always be, you know, sympathetic. You can work out payment plans with your owners, no problem. You have that discretion. But ultimately, if you wait months and months and months and months before you even initiate collections actions and before you get to the attorney, we're waiting then all those statutory notices before we can get to foreclosure. So you don't want an owner that owes, you know, 6-7 months before we get to foreclosure. You want to speed that process along so you guys aren't carrying that, you know, debt. Important to know what your language is regarding liability of a first mortgagee if there's a lender foreclosure. If the lender forecloses on an owner, association, their rights sort of get wiped out. So you need to know, okay, well, wait a minute, but now if the bank forecloses and they take title, do we get anything? What do we get? How does this work? What if it's what if it's not the owner or what if it's not the bank that takes title, but it's a third party purchaser? All of that's going to depend on, again, safe harbor language in the statute, whether or not you get to take advantage of that. It does limit what your recovery is, but your governing documents might have even worse language that limit your recovery even worse. You might get nothing. So that's something too to look at when you're thinking about doing any amendments. You want to make sure you maximize your recovery, especially following a lender foreclosure. Again, you're not going to get all of the money. No way that's happening, but at least if a lender takes title, safe harbor is your best case scenario. Maybe if a third party purchaser, you might get your money then. Third party liability, that's what we were just talking about. Financial reporting, we'll talk about that briefly. Again, get with your management team. So, you know, they typically will kind of handle that for you, but generally you need to know there are requirements. You have to have, you know, a certain financial report done every year within your fiscal year, within 90 days of the end of the year, or again, whatever date is in your bylaws, within 21 days, no later than 120 days from when the report's completed. If you have a third party do it, then you have to send a copy to your owners, or a notice that it's available and they can get a copy at no charge if they'd like. The level of financial reporting, that depends on what your total annual revenue is. The chart's there. Basically, if you have a lower total annual revenue, there's a less, you know, extensive financial report required, and then it goes up as we go. The highest level being an audited financial statement. This was something to be aware of. This was a change, part of the shenanigans that happened with that one very large association that had a lot of alleged crime happen. As of July 1st of 2024, regardless of your total annual revenue, if you're an association with at least 1,000 parcels, you have to do the audit. Because again, it was a big association with some shenanigans going on. All right, allegedly. If the association wants to raise the reporting level, 20% of your owners can petition to do that. So if you're at one of the lower levels, you could sort of move up the ranks and do something with a little more detail and all of that. The board could do that on its own too, but owners could petition to do that. All right. If you want to lower the reporting level, different threshold, you need a majority of your voting interests that are present at a meeting, of which quorum is obtained to do that, and you would go down. you can't prepare a sort of lower reporting level financial report in consecutive years. So, because again, we want to keep a close eye on what's going on with all the money. There are some disclosures that are required. Keep in mind for financial reports, basically that either says you have statutory reserves or that you don't, and that a special assessment might be, on the horizon. What did I do there? Contracts and bids. This is an important topic. I feel like we have a lot of clients that are entering into new contracts and changing vendors, doing projects, all of that good stuff. So keep in mind when you are looking at contracts, the first thing I'm going to say, and this is not, again, this is your free educational, but my 2 cents legal advice here. Have your attorneys look at your contracts, please. Please let your attorneys review your contracts. You are on a board, you have a fiduciary duty, you are basically running a company. Let your professionals, your attorneys, take a look at your contracts and make sure you're being protected. The association's protected. Now, not all contracts are required to be in writing, but we would suggest that they all are. If you have, a contract that's, sort of smaller, maybe for services, I understand if you're thinking, well, we can take a look. We don't need we don't need counsel to get involved. Then they're going to charge us. They're going to bill us, blah, blah, blah. But I can't tell you the number of contracts that we look at later because the board is not happy with the vendor or the contractor. And they say, hey, can you get us out of this? And then we have to take a look and say, well, we can, but here's the potential risk, or here's the penalty. It doesn't have a termination provision or whatever it is. And now it costs you more money on the back end. And if you had just spent the money in the beginning, we would have put in those provisions, the termination language, those protections for you. So something to be aware of. You want to make sure that any contract has the obligations of the parties, obviously. When we're talking about landscaping, it may sound silly, but you want to specify, are they doing 2 cuts a month or is it a cut every 2 weeks? Those may not be the same things. You might want to, take a look at these things with a real critical eye. Make sure everybody's on the same page. The biggest dispute we see with contractors, vendors is the scope of the actual work. And that goes for your management team too. Make sure you're looking at their contract very carefully. Make sure everybody's on the same page. The cost of the services, the frequency of the services, the personnel that's going to be employed, bidding's important. So you don't need to get a bid for everything. I know that's a common misconception. Everyone says if we're doing something, we need bids. Okay, really, you only need bids if the aggregate cost is going to be more than 10% of the annual budget. Then you need bids. And again, it doesn't actually say you need 3. The statute doesn't require that, but bids is plural. So we would say at least 2. But 3 is always a good idea. Why not? If you want to get 4 or 5, also great. Doesn't hurt anybody. You are not required to accept the lowest bid. Remember what I said in the very, very beginning, your fiduciary duty, you're protected by the business judgment rule. If you have a vendor that you're just more comfortable with because they did the project next door, and you're, friendly with someone on the board over there and they raved about them and said they were great, easy to work with, everything looks good, but maybe that bid comes in a little bit higher than somebody else, or maybe it's even the highest bid. Well, but if that's the vendor you want to go with, that's fine. You're okay. The board can make that decision. You don't have to go with the lowest. Sometimes there's very good reason that someone is the lowest, or sometimes the lowest bid is the best bid for you guys. It's really up to the board. If there's an emergency, you don't have to obtain competitive bids. That's good. If they're the only provider of something in the county, then you don't need to get another bid because, again, as a practical matter, that would be very difficult. I've only seen that happen once. There was one particular type of carpet that a condo association wanted to install in their halls. And I know that sounds silly, but apparently there was the only vendor in the county that made this particular kind of carpet. So they couldn't get bids. They could only, have the one. Interesting. All right. Some contracts are going to be exempt from the bidding process. Essentially, I kind of think of it as your professionals, but it's your employees, any attorney, accountant, architect, your CAM, actually. But if you do look at your CAM, if they do competitive bidding, you can actually enter into an agreement that's up to a 3-year period. Engineers, landscape architect, all those contracts have to be in writing, but you don't have to get competitive bids for them. Estoppel certificates, we're not going to get into this in too much detail. You guys have the slides here, but basically we spell out what an estoppel is. Hopefully you have an idea of what that is. Anytime there's going to be a transfer of a property or a sale or even just a refinance of a property, the owner is probably going to ask you for an estoppel. The bank's going to ask for an estoppel. They need to know what's owed to the association so they can factor in, how that's going to work as part of the sale negotiations or how that works into the refinancing. Estoppel requests go through the association, typically management. If the association has, a firm that's working on collections for them, in our case, if the file is here for collections, we want to do the estoppel because we want to do that money portion and make sure that the figures that we're working with are the figures, reflected on the estoppel. Because if your estoppel certificate is not correct and you haven't included all of the amounts owed, you haven't included a special assessment, or you just, goofed and left something off, and the owner or that person pays that amount outstanding that you put on the estoppel, well, now you are estopped from trying to go back and collect that extra amount that you left off. If you left money off and they paid, too bad, too sad, that money's gone now. You have to sort of eat it. So you have to make sure your estoppels are accurate. Again, it's usually something management takes care of for you, or your attorneys. Typically, estoppels also will outline, other factors. If there's a, parking space assigned to a lot or something, that'll be on there. All of those things. Here's the general information, the slides. The assessments are the important portion, like I said. Or even if there's an outstanding violation, against that lot, make sure you put it on the estoppel, because that new owner comes in and then you try and tell them, oh, you have to pressure wash your roof. The roof's dirty. And they say, well, what? Or something that's a little bit more permanent. Oh, that landscaping never got approved. You're going to have to remove that tree that's in the front yard. Well, what do you mean? The estoppel said there was no outstanding violation. The tree's been there for 2 years. So these are things you have to be aware of when you're preparing estoppels. And then there are fees that you can charge. But again, we can skip through estoppel stuff. Covenant enforcement. This is what's important and brings us there after we were talking about estoppels. All right. You're on the board. We've covered, you have a fiduciary duty. You have the duty to enforce your covenants. I hate to be the one to break it to you. I hate to tell you, you have this, sort of requirement, but you do. You have to be the bad guy. You have to enforce the governing documents uniformly and timely. You have to enforce these covenants, these restrictions, again, ARC stuff, pet stuff, nuisance conduct, 55 and over requirements. These are all restrictions and covenants that your community may have. They all should be in your governing documents. Nothing should be a mystery, and you should be enforcing these things going forward. And if you don't, you might run into a problem down the road where you can't enforce them. And then now there's a bit of a disservice to your owners who came into the community assuming, well, we're not going to have any pink and purple striped houses because we have ARC guidelines. Well, you better, make sure, again, you're doing your part to enforce these covenants. Anytime there's a covenant violation, you got to let your owners know, send them a warning, tell them what the violation is, tell them what they're violating. Article 10 says you can't, park on the sidewalk overnight. You have some enforcement tools. You might have to fine an owner. You might have to suspend their use rights, suspend their voting rights. Self-help is something we'll get into. And then ultimately you may end up in mediation and or litigation with an owner. Use right suspensions, fines. This is for anything other than non-payment. Non-payment, you send them to collections and there you go. But to fine or suspend use rights of an owner, which really just means possibly, turning off their clicker or whatever. If we're talking about fining, the fining procedure, again, is not very easy. And a lot of owners don't want to be on the fining committee, so it's a whole thing. But ultimately, it is something you have the ability to do. There's a 14-day notice of a hearing that needs to happen. The board really should approve the fine first and then send it to the hearing committee. That hearing has to be held within 90 days after that notice went out. The fining committee is a very specific group of people. It can't be anyone on the board or anyone really related to anybody on the board or a whole slew of people that it can't be, which really means you got to find other owners who are willing to really be the bad guy. within 7 days of and the committee's role is essentially to decide yay or nay with the fine. So an owner, can be fined. The board can decide, yes, there's this violation. It's been in place for, 10 days, $100 a day, up to $1,000 maybe. If you're in an HOA, you can actually go higher than $1,000, but that's only if that language is in your governing documents. So that's something to look at too. But let's assume it's $1,000 fine. The board decided it's $1,000 fine. They send it to the fining committee to confirm. So now the fining committee's role is yay or nay for the $1,000 fine. They do not get to compromise. They can't say, well, but this is a really nice guy. $1,000 is a lot of money. Let's make it $500. It's not how it works. It's yes or no. If the fine is imposed by the committee, they confirm it, then we move forward. If the committee doesn't confirm it, it's gone. It doesn't get imposed. Within 7 days after that hearing, the committee has to mail or email basically their findings. Again, we made this process of finding a little more difficult in recent years now. If the violation is cured before the hearing, the fine cannot be imposed. Now, again, as a practical matter, this gets a little annoying and difficult because if your meeting is at, 7 p.m. on a Thursday, so is your manager supposed to go do an inspection at, 6:45 and make sure that that fine wasn't cured beforehand? What if, the owner, whatever, mows his yard and that's what you were, the overgrown grass was the issue, and he mows his yard at 6:55 p.m. Okay, well now I guess we can't impose the fine, but as a practical matter, this makes life a little bit more difficult. So fining, that was something that was a focus in the last year's legislative changes. As we said, fines can't exceed $100 per violation unless there's something in the governing documents in terms of $1,000 in the aggregate. Again, possibly you can go higher depending on what's in your governing documents. And possibly you could lean for a fine in an HOA, not in a condo. In an HOA, you can do it if that authority is in your governing documents. But it has to be a fine of $1,000 or more. So a couple things to consider. Look at your governing documents, talk to your attorneys. Use right suspensions. Sometimes it's not the most practical thing. If you have a key fob, a transponder, something like that you can turn off, great. Okay, another weird change. Don't get mad at me about this one either. For some reason, trucks and garbage is a hot topic in the world of HOAs. All right, this was another change. Notwithstanding any provision to the contrary in your governing documents, a homeowners association may not levy a fine for any of the following. So they only said you can't levy a fine for this. Leaving your garbage receptacles at the curb or the end of the driveway within 24 hours before or after the designated garbage collection day or time. Now, again, don't get mad at me for this. So I have a client now that their townhomes, they're in a county where garbage pickup is 2 days a week. They're in townhomes. They have, small footprint, tight driveways, garbage cans on the end of every driveway. It is not the most aesthetically pleasing appearance. And garbage 2 days a week means if it's 24 hours on either side of 2 days a week, that means 6 days a week they have garbage cans out and there's nothing they can really do about them in terms of you can't fine for it now. Again, is that something we can get into in terms of the statute only says you can't fine, so you could still treat it as a violation in other ways? Maybe, not sure how that would go. That was a new change last year, so here we are. The other one is you can't leave holiday decorations or lights on a structure longer than indicated in the governing documents unless it's longer than 1 week after the association provides written notice of the violation to the parcel owner. That's another one you can't fine for. I don't know. I can't fully get into the mind of all the legislators. Sorry, guys.
Aren't there holidays that we invent like every week?
Right. Use right suspensions, failing to pay monetary obligations greater than 90 days. So if you do have an owner who's delinquent, they haven't paid for longer than 90 days. You don't have to go through the whole hearing committee, We don't have to go through all those steps. If they're delinquent longer than 90 days, the board alone can decide we're going to turn off their clicker. We're going to deactivate their transponder, whatever, ability you have to suspend their use rights. I will tell you, and that's at a board meeting, and then you send a notice that you've done it, all of that. I will tell you that it may sound silly, but that is something that annoys a lot of people. When they can't come through the gate easily and they have to stop and go through the visitor side and they have to talk to the guard every time, you get owners who get very annoyed by that. And all of a sudden, when the whole reason is, well, hey, you're behind, that might be enough for them to say, okay, what do I need to do? What do I owe you? Let's go. Let me pay. I've had an owner that, back in collections days, he called and he said, can I work out a payment plan? My wife is going to divorce me. My teenage daughter does not like that she has to stop at the guard gate, and my wife is going to kill me if I don't get this resolved. Now, again, was he being dramatic? Probably, but did he get him to pay? Great. So here we are. So if they're delinquent, that's something that can be done, board meeting. You can't prohibit them from getting into the community, but again, you can require that they go through the guard gate or the guest gate instead of the owner lane, things like that. Voting suspensions, this is tricky. Voting suspensions got complicated in the last couple years because, again, we kind of got back into this whole Kaufman language substantive right argument. So if you're thinking about suspending voting rights, I'll just give you the disclaimer that maybe you can do it if somebody is delinquent, but talk to your counsel. They might have to look at your governing documents. We might have to do a little bit of an analysis before you could just do it. All right, mandatory pre-suit mediation. So if you have a dispute, if you have an owner that's not doing what they're supposed to do, they have a violation, they haven't fixed the violation. Maybe you find them, they don't care. Maybe you didn't find them, still doesn't matter. They still haven't fixed the violation, so you're in the same spot. Maybe you've sent them multiple notices, you've given them multiple opportunities, and they're still doing the thing they're not supposed to be doing. They're still, parking on the grass, or they still haven't cut their hedges that are overgrown, or whatever the violation may be. Now what? And we get this all the time. And I've taught this course so many times, and I will have even property managers say to me, yeah, there's just nothing we can do, huh? No, there are things you can do, guys. You can definitely do things. Talk to your counsel, because the next step is really ramping up your litigation potentially and having your owners be subject to actual litigation and have your attorneys involved. First step is going to be pre-suit mediation for most of these things. We're going to go to mediation. There's going to be a third-party mediator, probably a retired judge, who is going to point out, the pros and cons of each side and the strengths and weaknesses of the arguments. But ultimately, if the owner's in the wrong, he's probably going to hear it now from a mediator too. And realistically, if you go to, if you end up in court and you go to a motion for injunctive relief and the judge sides with the association, the judge may also order that owner to pay the association's attorney's fees. So that's a pretty big, scary thing that could happen. Hopefully you can get it resolved maybe at mediation and we don't even have to go down that road. And luckily, maybe if a mediator tells this owner, here's what he's facing potentially, maybe that's enough to get him to come into compliance, but not always. Pre-suit mediation procedure, there is a specific form letter that needs to be sent. The statute lays it out. Association could also be on the receiving end of a pre-suit mediation demand. So let's make that clear too. If you get a demand that seems to indicate in any way, shape, or form it is a pre-suit mediation demand, send that to your attorneys right away. Because there's timeframes and you want to make sure you don't miss it. You have to respond within 20 days. Basically, it lists 5 mediators and says, let's go to mediation over whatever the issue is, a violation, something like that. And then you pick a mediator and you decide. There's a procedure here. You have 90 days to get that mediation scheduled. The parties have to share the cost of the mediator. If they can't get it resolved, okay, we can move on to filing a lawsuit. The thinking is this is supposed to be a cost savings. Get the parties to mediation, see if we can get it worked out without having to file a lawsuit. That's the goal, fingers crossed. Sometimes that does happen. That is great. Again, you could reach an impasse. Maybe your owner doesn't even respond. Maybe your owner responds, but then doesn't show up for mediation and you don't get it worked out. Many ways this could reach an impasse. But like I said, prevailing party attorney's fees, in theory, if you end up in a lawsuit and a judge decides the association is the winner, we'll keep it very simple. Judge says association wins. Owner might be responsible for the association's fees. It can go the other way. Like I said, the association could also be on the wrong side or could lose the lawsuit potentially. And the owner could win and the association might be responsible for the owner's fees as well. But important to note that if you don't comply with the mediation requirements, If you don't do what you're supposed to do, the penalty can then be, if you fail to participate in pre-suit mediation, that you cannot recover attorney's fees in any subsequent litigation. So that's a big penalty. So if that owner doesn't comply with mediation, doesn't show up, doesn't pay the mediator fee, doesn't answer or whatever else, and you end up filing that lawsuit, and let's say the association was wrong and that owner actually wins the lawsuit. Well, penalty against that owner is he's not getting his fees. So it's a big penalty. Now we're almost at the end here. This is the last, but still significant consideration for you guys when we're talking about covenant violations and maintenance issues and things like that. When we are in the world of HOAs, a lot of the violations involve, maintenance of the lot. So how the grass looks, how the landscaping looks, how the house actually looks, how the roof might, the status of the roof, the condition of the building, all of those things. Now, this is important because if it's something, it sounds silly, but if it's something little like, hey, this owner isn't properly weeding his driveway. Okay, so we send a violation notice, we can pursue all of these things, we can fine them, we can do all, whatever, all of the steps we've taken. One of the other steps that we would consider is, does your declaration authorize the association to take self-help, to do self-help? Do you have the authority as the association to go and do that maintenance, to correct that violation yourself, so to speak? So the association takes care of it. A, do you have the authority to do that at all? B, do you have the authority to do that and then charge the cost back to the owner? Maybe as an assessment or something like that. Oh, we'll just have our landscapers go cut the grass. What's the requirement? Maybe the declaration says something like 30 days notice, and the association can perform the maintenance and charge it back to the owner, something like that. Great. Easy peasy. I'll have our landscapers go and cut that hedge, and for that extra, session or whatever, we can charge the owner back the $50 or whatever. Okay, that's nice and easy. It gets a little more complicated when the self-help is related to a more significant violation. If the violation is, hey, your roof is in terrible condition, we need it pressure washed. Or, your house is looking a little lackluster and it needs to be painted. Now that's a big thing. That's a big difference if we're talking about, wait, is the association going to go in and paint their house? That seems crazy. Is the association going to go pressure wash someone's roof? We don't want to be responsible to have a vendor up on someone else's roof. So this changes the analysis. And the self-help thing used to be, because the declarations typically say that the association has that option. It used to be clear cut. Okay, it's an option. For something like a big like that, we're not doing it. It's fine. We'll just pursue litigation. We'll get the injunctive relief. But now there's some language in the statute that came out in case law that because an injunction requires that there's no other remedy available, there's language in there in terms of, so if self-help is an option, you might have to try and exercise self-help before we can go to court. So that's an important consideration, again, depending on what kind of violation we're talking about. Maybe it's something the association would never be able to cure. Obviously, if someone needs a new roof and needs, a permit, the association can't go get a permit for, Mr. Jones's house. So that wouldn't be possible anyway. So lots of considerations, things to think about when we're talking about curing these maintenance violations, that sort of thing. That's something, again, if you're even thinking about amendments, talk to your attorneys about probably removing self-help from your declaration. All right, we got through it all. 2 hours and 40 minutes. Not bad.
Not bad at all. Not bad at all. You did wonderful.
Okay. And like I said, guys, for any of those slides I kind of skimmed through, you have them, you're going to have them, so you can go through them with the fine-tooth comb.
And so thank you for that, Emily. And while you're going through, we have a bunch of questions submitted. Emily's not going to be able to answer all of them. She's going to go through a few of them. Okay.
Yeah.
And but while she's looking through that, if you haven't already done so, please press the chat button, not to be confused with the Q&A module that many of you have already been using to ask questions. Press the chat module simply so it appears. Like I said earlier a few times, it's going to say chat is disabled. There's nothing for you to enable. That just means you can't send chats our way, but we can still send stuff your way. Some of you have said too in the Q&A that the link is not working. You saw the link in there. That will mostly be, you likely have a pop-up blocker on your browser or something to that effect that is not allowing the link to pop up. So if that happens, if the link's not working, highlight it, then hit Control C on your keyboard to copy the link. On a Mac, it would be Command and C. So copy the link, then paste it into the browser yourself, and then it will work for you that way. So that's one way to get around it. I'll go over it much more slowly, including sharing my screen and showing you the evaluation process after Emily is completed with some of the Q&A. And the last thing I'll mention before turning it back over to Emily is that the required part is over. While we want you to hang out and listen to the Q&A, you don't have to. After you do the required evaluation that we just explained, after you do that, you can go. You're done. You're good. You're certified. And then within 5 to 7 business days, you will get a email from seminars@kbrlegal.com. That email will contain some of the links, including the slides once again, as well as an attachment, a PDF attachment of your attendance certificate. The reason for the 5 to 7 day delay, we verify attendance to make sure you were here in full for the entire thing. We cross-check that information with the evaluation, and then we get the certificates out to you. Be sure to keep tabs on your spam and junk folders. AOL, Yahoo, and Bell South. Those three extensions are notorious for emails with attachments from businesses ending up in spam. So if you don't see anything in your inbox by this time next week, check your spam and enter the seminars@kbrlegal.com email address in the search. Emily, back to you.
All right, so a couple things we can clear up on these questions. Steven says, is a postmark on a mailed notice sufficient to meet the 14-day requirement? That is probably, good evidence that you complied with the 14-day requirement, but every 14-day notice is essentially going to require an affidavit too. So you have to have that affidavit in the file, which again, you can put together sort of after the fact, as long as the person who is signing it is swearing that they sent that on that postmark date, or, whatever it is. So you can do that. Someone said, if an owner member has provided their email address to the association, does that constitute consent to received email notices, documents, etc. via email from the HOA? That's a good question, Deborah. So again, just because an owner has emailed maybe the manager or, whatever it is, or even if they've given it to maybe the platform that the association uses, or the website requires an email address or login or something like that. It depends, because you should be actively consenting to get your electronic notices via email. So if that's not what you consented to, if you just sent an email to your manager with a question, that doesn't mean now that everything needs to be sent to you via email. Now, again, if you want that, great. Just make sure the owner, your manager knows that. If they do electronic notices, obviously, then you want to make sure you opt in, but that consent should be clear that you've really opted in for that. George said at some board meetings, owners should be permitted to speak before the vote. Not all boards do that. Speaking after is futile. There should be a law. George, you're right. It's not required by law, but here we are. If the documents require 50%, only 30% is required. I assume that's about the quorum requirement. Yes. So most of your governing documents will probably say something higher. Traditionally, they do. It'll say a majority. It'll say 50%. It'll say whatever for your quorum requirement for your membership, meetings. But if that's the case, if they say something higher, 30% is the number we're using, or is the figure we're using when we calculate what our quorum number is. If you have something lower, you use the lower number. So on the off chance you actually have documents that say 20%, great, use the 20%. All right. George also made another point. Many HOA owners realize that when they use a proxy for voting, then their voting is not secret and someone can know how they voted. Yeah, you're right. So if you're voting on, proposed amendments, and maybe you can't make the meeting, or you don't want to go to the meeting because you just don't feel like it, you might return a limited proxy where you vote yes in favor of proposed amendment number 1, no in favor, not in favor of proposed amendment number 2. And yes, in theory, someone could look at those proxies and then someone might say to you, hey, why'd you vote against number 2? Number 2 was a good amendment. All right, well, there you go. Can electronic voting be limited to those in attendance? No, if you do electronic voting, the whole purpose is, they could vote in advance whenever the voting takes place. I guess in theory, if you're doing a sort of a live vote, that would maybe that could be an issue, but we'd have to talk about it factually. What happens in an election if you have 5 people running, but you have 7 positions? So good question, Ed. Essentially, you can seat those 5. The 5 take the 5 spots that are available, but now you have 2 vacancies. So the board can either decide at that time, if we had no other candidates, the board can function the way it is as 5. Maybe you want to look at the governing documents, see if they want to change the size of the board. Sometimes that is something that can be done by the board. Sometimes it requires a membership vote. If it's a board vote, maybe the board just decides, we're going to change the size. We're going to stay with 5. It's easier, whatever it is. And we're good. We're all set. Or potentially the board says, well, we do want 7. We'd like some extra help. And you can you can start to, I don't want to say campaign, but kind of do email blast feelers out to the community. Hey, does anyone else want to be on the board? Talk to your neighbors. And then they could appoint somebody down the road. They could appoint 2 more people and fill those spots. They don't have to take, the first volunteer. If you have a vacancy and that one really annoying person who comes to every meeting and just drives the board crazy is the only one who volunteers, and you don't want that person on the board with you, you don't have to take them because they were the only person who raised their hand. So, it's really, you have many options, but really you'd want to look at what the governing documents say if you want to switch the size of the board, if you want to appoint people later, but you could function with 5, with 2 empty seats, but just remember, you're still a board of 7 until you officially change it or until you, appoint people. So, all right. Someone said, what happened if it was a felony in another state? If it's a felony that would be, comparable to a felony here, then potentially, again, that same rule applies. They're not eligible unless their rights have been restored for 5 years. Again, typically you're not going to know about the felonies. Logistically, I think I've seen it come up twice in 13 years and a million elections at this point. Can the board act by unanimous consent? If so, can that consent be obtained by email? Good question. So this is something now we're kind of getting into advanced level. This is a little bit beyond Cliff Notes, so to speak. But 617, chapter 617, which we did reference today, says that basically if the board is all unanimous, they can act by written resolution is what it is. So all board members could sign off on a written resolution, and it's the same as if they had voted at a properly noticed meeting if they're unanimous. So that's something that is another tool available potentially to you, where again, maybe you don't have time to have a meeting. Maybe it's something that you don't, is a smaller priority. You don't need to have a board meeting for it, but you're all on the same page. If you're all willing to sign off on that action, you could do it by written resolution. All right. All right. So other questions about board meetings, again, talk to your counsel about maybe setting up some rules in terms of how to kind of effectively actually, and productively conduct your meetings. So you keep your owners on task, but you guys can stay, again, on task. Talk to your counsel and adopt some rules about that.
Hey, Emily, before your next question, David and others who are asking, this recording will be on kbrlegal.com within a few business days under the webinars, resources, then webinars and video section from the main menu. Back to you.
You don't remind me of that. That always freaks me out. I hate the thought that there's like videos of me out there in the world. I was not meant to be an influencer, guys. All right. Once litigation is completed, this is another good question, George, are the records open to the owners? So interesting. Now, again, when we talk about litigation, anything that's in the public records, it's in the docket that you could find by doing, a search of Broward County, that's public record. Anyone could look that up. You could look up, certain pleadings for certain cases. Now, if the association enters into some sort of settlement agreement with an owner, typically the settlement agreement itself is not going to be on the docket, but the settlement agreement is part of the official records. So a lot of times the official records, the settlement agreement will say in there that the owners are not supposed to disclose it. The board is not supposed to disclose the terms. Because again, maybe it was a settlement agreement that was entered into where nobody's admitting guilt, nobody's admitting any fault, whatever, maybe some money is exchanged, whatever it may be. Part of that probably says that the owners aren't going to disclose it. The board's not going to disclose it. Association's not going to disclose it, except for when they are required by statute. So yes, potentially as part of the official records, once that case is settled. So potentially your owners maybe could see a settlement agreement once the case is closed. But again, they shouldn't be, that's something that, your board shouldn't advertise, the owner shouldn't advertise, but it could be something that in theory, an owner could find in the official records. All right. All right, there's a lot going on here. Bulk internet agreements, talk to your counsel. Someone says, does membership have to approve? Probably not, unless there's something in your documents. Statute allows it, so you want to talk to your counsel if you're looking into doing any bulk internet agreements. All right. Can the board refer to a resident by name when imposing a fine? Yes. I mean, you can talk about your owners by name. Generally, there's sort of an understanding that when we are talking about violations, when we're talking about maybe even delinquencies, maybe about fines, there's kind of a level of let's try to be respectful and not say someone's name. Just out of, again, kind of as a courtesy, but ultimately you can. I would suggest you use maybe the address, the lot number, some other, if you have an account number, if your management team, tracks it that way, as opposed to saying, at an open board meeting that, Mr. Jones owes the association $5,000. It's a little bit easier when you're going through the ledgers or the ARs or whatever to just say, okay, and we have an outstanding balance on, lot, whatever it is, 2, or, 123 Green Street owes an outstanding balance going back, 6 months, whatever. But really, there's nothing to prohibit you from using a name. But we just warn you because, again, we don't want you to say things at board meetings that could then come back to bite you. So be very careful with what you're saying. All right. Thank you, everybody, about the kind words. I think, Jeff, we're done.